morning, everybody. Welcome to the Courtroom Files Live. It's a Thursday, the 30th of October. It's Halloween Eve. We probably have some spooky stuff coming up for you today or tomorrow for sure. But let's start with first appearances. Wade Mercer.
Great. Ladies and gentlemen, at the jail, I'm Wade Mercer. I'm the county judge in Jackson County doing first appearances this morning. We always have two attorneys involved in the first appearance process. I know that you can see and hear Mr. John McDaniel. He's an assistant public defender. He's at the jail. I want to make sure you can see and hear our prosecutor, Ms. Harris. I want to ask that she introduce herself.
Bailey Harris on behalf of the state.
Thank you. Can you see and hear both of us at the courthouse, Corporal?
Yes, Your Honor.
Great. We only have two cases today. The first is Billy Mears, Jr.
Yes, sir.
Mr. Mears, good morning. Mr. Mears, you're here because you have been accused of one count. It's a failure to appear case from the circuit court. It's a failure to register as a sex offender properly. The warrant has no bond on it. Mr. Mears, what that means is you're going to be held with no bond until you can get over to circuit court and get this allegation against you resolved. Let's see what kind of court date it was. And I might can tell you it was an arraignment date. So the next arraignment date, I believe, is going to be you're going to miss the November 4th docket. So it's probably going to be the December 2nd docket. It's all based on your date of arrest. But Mr. Mears, you should be in court December 2nd, if not before then, and ask for an attorney appointed to represent you if you wish, and we'll go from there. Any questions?
I have another case like this in Liberty County that's been going for like 3 years. And I talked to my attorney, Courtney Freeman, yesterday about all this because I turned myself in yesterday. She wants to get the attorney on this case to link with her on that case there.
Okay. So when you get appointed attorney here, let the attorney know that. But
Yes, sir.
Judge Garcia is not going to let this case linger for 3 years. So this case is probably going to move a lot quicker, hopefully. Okay.
Yes, sir. Thank you.
Have a good day, sir.
Yes, sir. You too.
Quantavious White is next. Mr. White, good morning. Mr. White, I think I may have been the judge to first appear you, and I set your bond on your local charges. And I think I held you because you were out on bond in Gadsden County. We held you and asked the state to notify Gadsden County of your arrest and see if they're going to try to revoke your bond. I pulled it up this morning, but I'm pulling up the Gadsden County case now, which is 24-423 CF. And there has been no type of motion to revoke the bond filed in Gadsden County, but Ms. Harris may have some more information. So listen to our prosecutor, Ms. Harris.
Your Honor, we spoke with Gadsden County this morning, and the ASA on the Gadsden County case was in trial, but we spoke with the other ASA, and he was unaware that this was going on, but he was going to put in a motion this morning to revoke his bond.
So take that for what it's worth. Mr. White, I'm not going to hold you any longer for them because I've held you a week already. They've had a week to get this done, and it hasn't been done. I have no idea why it hasn't, but it hasn't been. But here's the dilemma you face. You have the right to post bond in Jackson County, and if you do, you're going to be released. But if they're successful in revoking your bond, there may be another bond issued by a Gadsden County judge, could be today. So you could be wasting money by getting out of jail in one county and going back into custody in another. But you have the right to post the bond. That's entirely up to you. Your bond in Jackson County looks like it's $10,000. You're already on an arraignment docket here, and we'll see what happens. If you post the bond, you'll go to court in Gadsden County at some point. If you don't post the bond, you'll come to court in Jackson County and deal with Gadsden County at a later date. Mr. White,
Judge, I guess you didn't see. I assume you didn't see my text message, but I mean, he's going to plan on bonding out. So they got the court dates on the same date, the same time, November 4th. Can we move his to the afternoon docket on November 4th or?
Well, what the clerk has explained to me, Mr. McDaniel, is if he posts bond, he will automatically go to the afternoon docket. So the notice that you were given for November 4th at 8:30 is if you're in custody. Is that right, Don? But if you post bond in Jackson County, you'll still be the same date, but you'll be in the afternoon docket. Is it 1 or 1:30?
I think it's 1:30.
At 1:30. So, Mr. White, if you post bond here, you'll move to the afternoon docket because the in custodies are in the morning, the out of custodies are in the afternoon on the same day. But keep in mind, if you may want to talk to the authorities in Gadsden County or get your friends and family to, because it's certainly possible. You could be in the jail parking lot waiting on somebody to pick you up. Gadsden County send somebody over here to serve that other warrant, and you just wasted however much money you posted bond for. So you may want to find out more about Gaston County before you make that decision, but you've heard everything I've heard from Ms. Harris, and that's what she was told this morning. Mr. White, any questions?
Judge, I'm just gonna let him know that Jake sent him an email. I've seen the email. They knew about it. This is not the first time, but essentially every time. So I don't believe that they're gonna have it filed today by any means. So I just my recommendation, if he wants to bond out, then bond out. Yeah.
It's up to you, Mr. White. Proceed at your own peril, as they say, okay?
Yep.
Mr. McDaniel, it's everything I had on my list this morning. Anything else from the public defender's office?
No, Your Honor.
All right, that's going to wrap up first appearances down there in Florida this morning for Wade Mercer. That very short, very light docket down there. So it's kind of a weird day in the courtrooms. There are a few courts that are active. We have some landlord-tenant, and we don't really like to go there unless it's in Judge Simpson's court because, well, they're always more interesting. Everything is more interesting in Judge Simpson's court, I suppose. So we'll have to consider that. We do have a lot of other areas we can go, however, so we're never short on content here at TCF, that's for sure. Speaking of Judge Simpson, let's head over there now. The Honorable Judge C. Cedric Simpson. J. Cedric Simpson. It's a Thursday. Presiding.
You may be seated. Oh. Whenever I look over there, I never know who. Ms. Feltes.
Good morning, Your Honor. Actually, Lonnie Feltus for the people. Your Honor, at this time, people would waive any conflict between this honorable court and the honorable defender. We do not believe that any conflict exists. We make way for the avoidance of all doubt.
Thank you.
Assistant Public Defender Hannah Apple, on behalf of the Public Defender's Office, our office does not believe that a conflict exists between this honorable court and the Public Defender's Office. When it arise, our office would waive that conflict. This court could hear this matter.
All right. The court, for its part, also does not believe there's a conflict either, and Michigan court rules of the cases decided there.
I went to see him. I'll try again. Ms. Anderson from my office asked me to let you know there's a new case that's on the arraignment list today. I don't know if the court wanted to.
Today?
Yeah. He's on the 130 docket. It looks like it's a failure to return rental property, 1,000 to 20.
Okay. So what I'll do is I'll adjourn this to the 13th, 2025, 9 a.m. Bond will continue. Can you let the
You go to court on the
magistrate
15th, they got
now
adjourned.
to put this on the 13th? I think that's the
Oh,
date
no.
they'd land anyway. Thank you, sir.
I'll come visit you, Mr. Myers.
Well, I'll tell you what he said.
Pardon? Okay, he's got it. Court does call the case. People versus Kyle Wilson.
I'm on behalf of Mr. Wilson, who is approaching.
Kyle Wilson. You're requesting an adjournment. Can counsel approach, please?
All right. Well, he's gone private there. Good morning again. It's the Courtroom Files Live. If you're wondering what happened there just a moment ago, we had a little time skip. Freya, our cat, stepped on the keyboard. So these things happen, but we are live. We are hanging out with Judge Simpson. We've got a few other places we can go. And of course, I encourage you, use this time to encourage you to play TCF Bingo. Yes, it's not just courtroom, it's courtroom with fun. It's TCF Bingo. You can get your bingo card, all that information on your linked up and on the screen there. So you can play bingo with us and everything that says Dan, since I'm filling in for Dan, Michael Groff here, filling in for Dan Soul for the next week and a half right here on TCF Live. Everything that says Dan, just substitute my name and our cat, Freya, instead of Ellie. But it's all basically the same. I'll probably be eating on camera at some point. I know that's a square. I don't like to eat on camera, but I suppose that's something that probably happen. All right. Well, Judge Simpson is doing that. We'll hang here for just a minute if he doesn't come back. Sometimes he goes, it's the lawyer's approach, and it's 30 minutes before he comes. Oh, he's coming back now. Here we go.
You're requesting an adjournment.
Yes, and a moment to address bond, Your Honor.
All right. Probable cause conference will be adjourned to November 13th, 2025, 9 a.m. As to bond.
Esteban, Your Honor, we were gonna be asking for an adjournment a reduction in the bond, if not a personal recognizance bond, perhaps a 10% privilege. Mr. Wilson, to my knowledge, has not had any bond violations while he has been in custody. He has a really good full-time job that he's afraid to lose. He does have 4 children to provide for. One of his children typically stays with him, is now staying with his sister. One of his other children, he usually stays with throughout the day. So he'd like to be able to get released so he can go back and take care of his children and be able to provide for them. He also has let me know that he has somewhere else to go. He has either, he can either go to his sister's house or to one of his children's mother's addresses. Neither of those are in Washtenaw. He's okay getting released on a GPS tether. He has no reason to come back to Washtenaw except for this case. The house that he could go to, his job is in Southfield. And then I believe your sister's address is
Oak Park.
Oak Park, and then the child's mother is in Westland. So really far away from here. Well, not really far away, but far enough. We can do a hot zone tether with a GPS zone that's quite big. He will not violate. He just wants to be able to get back to his job so he doesn't lose it and be able to provide for his children.
Respond.
Your Honor, I'm going to strongly object to any modification of bond. In this case, he originally requested $150,000. He is currently on probation out of the 6th Circuit Court for a GBH and DV conviction that he pled no contest to. As far as I saw on their website, for that case, a bench warrant had been issued at this time. In this case,
Hold on. I just want to make sure I understand it. At the time, the alleged time of this offense, he's on probation.
for a DV, GBH, and DV charge that he pled.
All right. And there's a bench warrant that's being issued. Was that bench warrant issued in response, if you know, to these charges, or was there something else where he was not compliant?
I believe it's these. I don't know exactly. It just says order for bench warrant expedited on 10/22 of this year.
If I may, Your Honor.
On 10/22. So that was probably, go ahead, Counsel.
Yes, I believe that's his violation. In Wayne, he is in contact with his probation officer. It's a good relationship with her. He knows about that. He's compliant with that. He was about to be discharged November. He had done everything he's supposed to do. He was ordered to do, anger management classes, and he completed what he was supposed to complete and is still doing more classes on his own, whim. He felt like it was helping him. And again, he was doing very well. He was about to be discharged. He was waiting on the discharge letters.
He was doing everything he was supposed to do except have contact with the police and potentially commit other offenses.
Yes,
Right?
Your Honor.
That's what you meant to say.
That's what I meant.
Go ahead.
He was about to think about other strangulation and that's around this case. And in this case, the victim is extremely terrified of him. She reported 2 different strangulation incidents, one that was out of county and one in Washtenaw. And that the defendant had left with her car for an extended period of time and she wanted it back from errands. He became extremely upset, told her, "Stop telling me what to do or I'll beat your ass." He then balled up his fist, began pushing at her as if he was going to hit her, then pushed her to the ground, which caused her to fall on top of her son. He then had one hand around her throat, one over her mouth. While she's still on top of the child, strangled her. And when law enforcement arrives, he refuses to come out of the house. Officers had to kick in the door, which it was stopped partially by the deadbolt. They eventually were able to kick it open fully and arrest him, at which point he was still tensing up, pulling away. And during these assaults, he had also told the victim, "I wouldn't kill you because nobody's worth me going to jail for life. I've had someone else do it." So I have extreme concerns given that a new strangulation case occurs while he's about to be probation for a strangulation case that he pled to. And he's also resisting law enforcement officers at the scene of this event. So I have concerns for the victims, the community, law enforcement, and the high lethality factors in this case. So I would reject any modification of bond at this time.
I just add, Your Honor, that these are just allegations at this point.
Yeah, but I'm presuming that some of that we can probably see because the door, there's physical damage to the door.
Yeah.
And while there are allegations, certainly there becomes a problem if all of this is going on and there's a lack of cooperation with police officers.
I don't, again, want to speak to the exact details of the case, but from my review of the video, Your Honor, again, I don't want to get into the details, but it's definitely questionable whether he was resisting arrest or not. In my review of the videos.
In looking at this, frankly, his bond currently is set at $75,000 cash surety. I'm going to deny the request for a reduction. I do find the defendant, having been on probation and then allegedly committing these offenses, to be a danger and risk to the public. Quite frankly, and I did not take their indication of what they had requested as a request to raise the bond in this case. I will decline to do so, although I think that the bond in this court's mind, based upon what I'm seeing, may be set too low. So I'm going to leave the bond where it is. I'll have his bond continue, but I'm certainly not reducing it.
Thank you, Your Honor. Understood.
Thank you. Court does call the case People versus Colette Haynes.
Not Overwater, Assistant Prosecuting Attorney for the People.
Foster Tucker on behalf of Colette Haynes.
Hello,
Hello,
your name?
Colette Haynes.
Why was Mr. Bernstein stepping in for you?
Sorry, Your Honor, I had another court.
Oh, we would have rather heard from you. Just saying. But go ahead. Anyway, what are we doing?
Your Honor, we're just requesting an adjournment to try and work out a resolution.
Cause conference November 20th, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you. Thank you, ma'am.
Thank you.
Court does call the case of the People versus Marissa Dix.
Good morning, Your Honor. Great to see you. Robert Ellman with and on behalf of Marissa Dix. Ms. Dix, you please state your name for the record.
Marissa Dix, good morning, Your Honor.
Good morning. Thank you, Your Honor. We'd be asking for an adjournment in this matter. We just need a little time to try to reach out a resolution here.
Probable cause conference will be adjourned to November 13th, 2025, 9 a.m.
Thank you, Your Honor.
Thank you. Bond continued. Thank you.
Thank you, Your Honor. That sounds good. Thank you so much.
Court calls case People versus John Hacker. John Hacker?
Yes.
All right. Mr. Jerkis is here. All right. What are we doing on this case?
Jerkis on behalf of the defendant. I'm asking for a preliminary examination, Your Honor.
All right. Discovery is complete.
Yes.
People have their witnesses available. The 10th,
Could we potentially go to the next week, please, Your Honor?
the next week. For all of that, the 7th, the 18th. Is that right?
Yes.
You want to go that far out, the 18th? Any objection, Mr. Jerkis?
I'd certainly like to have it as soon as possible, but if the prosecutor's asking
Well,
for it,
if you want it as soon as possible, that's when it gets set. So do you want the 10th or the 13th? I'll set it for next week. Which is better for
I'd ask for next week.
Okay, I know. However, do you want the 10th or the 13th? You haven't been paying attention. Listen, because of Veterans Day, the schedule's kind of messed up. So I have for the where I would set them, I have the Monday, the 10th, and I also have the 13th.
I'll choose the 13th. I'll be requesting
All
the
right.
13th.
Preliminary examination in this matter will be set for November 13th, 2025. That's at 2 p.m. That is before me.
For you?
That was a question?
Yes.
Is it?
Yeah.
Didn't I do one before?
Mhm.
Was Faltaz not paying attention? Yeah, that's before me. Yeah, I do exams.
It's true.
Yeah,
I've seen it.
I can do those. Is that right? Yep, thank you, Aaron. 13th at 2. Bond will continue. Thank you, sir.
Thank you.
Yes, there are 3 judges on that week.
That's what I was thinking.
You and Jerkis weren't paying attention. Court does call the case. Cases of People versus Cartier Drain.
Middleton Water Assistant Prosecuting Attorney for the People.
This is Public Defendant Nicholas Bukovich on behalf of Mr. Drains.
And Sherilyn Foster Tucker on behalf of Mr. Drains on the case ending in 1685.
Your name, sir?
State your name.
Cartier Drains.
Thank you. And both of you are requesting an adjournment.
That is correct. Your Honor.
Yeah.
That's correct for me.
Okay.
Your Honor, is my understanding in my case, the APA is requesting an adjournment. I know we had a bench conference last time to discuss potential issues in Mr. Drain's case. So I would be asking for the soonest possible adjournment because this is the case that has the most great impact in holding him.
Could the issues be resolved by the 6th in terms of what needed to be looked at? That question was directed to the prosecutor.
I'm sorry, Your Honor.
Go ahead.
I don't know. I don't know the answer to that, but we can certainly try.
Well, here's what I'll do on both of these then, because presumably these cases are traveling together for a reason. I'll adjourn both of them to November 6th, 2025, 9 a.m. Bond will continue.
Yes, Your Honor, may I briefly address bond in the older case?
You asked for the nearest date and bond. Go for it.
Sure, Your Honor.
Doing so well.
Sure, Your Honor. Your Honor, I'll be asking for a reduction in bond in my case that the public defender currently represents him on. Today, we did request an adjournment. As the prosecution does need to look into this matter a little bit more, I do understand the need for that. However, this is the case that does have the most severe impact on holding him because in this case with Ms. Foster Tucker, he has a low cash bond. He does have an address at which he can reside at if he is to be released from custody. And he has been regularly appearing at all his court dates in the past. So I do not believe my client is a flight risk. This was prior to him being incarcerated as well. So at this time, Your Honor, I'll be requesting consideration of a PR bond or reduction in bond to another low cash bond.
Did we give him a PR bond before and then he messed that up? And there is another issue. I mean, not only did he not appear, but there's also what at least may be a other violation as it regards this case, right? I mean, that's what needed to be looked into.
Yes, understood, Your Honor.
I'm going to deny the request for a bond reduction. I'm going to have his bond continue at this time. I've given him my next available date. They'll look into that and do that. Bond on both cases will continue.
Thank you, Your Honor.
Thank you.
Court calls the case People versus Devon Gilliard. Gilliard? Printing's getting bad. Gilliard.
And good morning, Your Honor, to you and your staff attorney, Maxwell Dubin, P number 86012, on behalf of Mr. Galliard, who appears to my right. Please state your name for the judge.
Devon Gilliard.
Okay.
Your Honor, today's the
What was
date,
your P number?
86012.
Oh, okay. Never mind.
What you thought? What do you think I said?
No, I just.
Up or down?
No,
Did I talk too
I
fast?
heard it.
Could-
No, I heard it.
I talk fast.
Mine's a 3, like seems like a 2.
I've seen some
Those
ones.
things a 1. Yeah. And you're like an 8.
Yeah.
Wow. Okay, go ahead. I'm sorry.
No, I'm seeing ones past mine now, so I feel better about it. But
Don't.
okay.
All right, go ahead.
Save it. I got it. Regardless, Your Honor, take
Your name, sir, if you didn't.
Oh, Devon Gilliard.
Thank you. All right, what are we doing?
Today's the date and time set for PCC. I was retained on this matter. I have received discovery. I've not gotten a chance to go through it. I am asking for a adjournment. We are prepared to waive 21 days on the record here today, Your Honor.
That objection. November 20th, 2025, 9 a.m.
I would like to briefly address bond if.
He's out. I can change that.
No.
No, okay, go ahead. No, I'm just.
No, I know.
No.
He was in the military, Your Honor, so he's very prompt, upright. So don't.
What
take that.
branch?
Yeah.
Army.
Army?
I'm retired, yes, sir.
You're like 12. How are you?
Medically retired off PTSD, bipolar disorder.
Got it. All right. Go ahead.
Which actually is a great leeway into my point, Your Honor. My client, he understands the allegations and what he's being accused of. That being said, Your Honor, what we are requesting here today is my client does live in Fort Bliss, Texas. His only connection up here is with the victim in this case. But we are requesting.
He lives in where?
Fort Bliss, Texas.
On purpose.
No, he's from.
No, never mind. Never mind. That was just my statement. Go ahead.
He lives there, Your Honor. Everything he has is there. He has a home there. I'm requesting that he be able to return to that home. He has retained my office. He's been in constant communication with me. He doesn't have a vast criminal history. He has no criminal history of convictions at all. He's not a flight risk nor danger to the community. And he, in theory, would be farther away from the victim, which I believe the court's ultimate goal because he is on tether, is to keep him away from the victim and keep him returning to court, which is all possible. There is one thing on his record while he was in the military. However, there was no conviction, nothing came of it. So he has no convictions either. I don't think he's a flight risk in any way, shape, or form. If he was able to get the opportunity to go on Zoom, he would go on Zoom, but he has also informed me that if he did have to come back in person, he would travel back here in person. And the only other, I know I'm throwing a lot at you, promotion, is when the arrest did occur, the officers gave his suitcase with his only clothes in here to the victim. He did not want to go back and get that without court order or anything like that. So we're just asking for the one civil standby as well for him to get his belongings from there.
You arrange. The civil standby will be arranged with the police department. So I don't.
Okay, just do that on
anything
it.
to do with that.
Okay.
Your Honor, I would have no objection to civil standby. However, I would have concerns with him going all the way back to Texas, given this case. I would have concerns about him coming back in person for the exam and things. I just have concerns. He does have a past from when he was in the Army with domestic violence. They weren't convictions. They were, I think, adjudicated differently, like classes or something based on what I read. They weren't ended up in convictions though. So I do have concerns, given that he would be across the country, getting him back here for this case.
Is Texas really across the country?
He's here today with me.
Yeah, because he told him he couldn't leave the state.
Well,
no,
fair.
Who is that? Okay. So he doesn't have a resident here.
No, Your Honor. He was forced to get an Airbnb. Am I correct on saying that? He has no residence. He had no connection here except for the victim. No family, no anything.
How long were you in the military, sir?
I did 10 years. Yes, sir.
10 years?
Yes, sir.
Wow. I think I'm going to let him go to Texas. I think if the military can trust him to fly around everywhere, put his life in danger for 10 years, I think I can trust him to Texas and come back when I tell him. So you prepare an order, counsel, I'll sign it that he may reside in Texas, but he needs to come back for any court date or when ordered by the court.
Absolutely, Your Honor, and that's understood. We appreciate that, and I appreciate you putting your faith in my client as do I. He does have a tether on. I don't know if that's something you want him to keep on or he's able to keep on.
Oh, no, he'll keep the tether.
Okay.
They're used to that in Texas.
No, they can. He's able to.
No, I don't know.
He's able to.
I just said that.
He's able to do that though, right? He can keep the tether on and still go to Texas, correct?
He can go anywhere
Awesome.
if he keeps that tether
Yeah,
on,
yep.
and we will know exactly where he is.
Perfect. Exactly. That goes to my monitor. So thank you. Good to
Thank
see
you.
you and your staff. And I'll see you guys next time.
And you.
And you said November 20th at what time, Your Honor?
9 a.m.
9 a.m. Sounds good. Thank you, Your Honor.
Sir.
You would think as an 8, he'd be able to retain that for that. Anyway, no,
I'm sorry to disappoint.
it's okay. I just thought I just make that comment. Anyway.
All right, good morning, everybody. Welcome. It's the Courtroom Files Live. It is Thursday, the 30th of October. Michael Groff here, filling in for Dan Soul, and he is, he's crossed the country. You saw him in the pre-show if you're a channel member. He was up there in, not far away, really, from Judge Simpson, and I think he was in Ohio this morning, heading up to Michigan this weekend for his daughter's wedding. So we wish her, of course, all the best, and him and his family and everybody to have a great time. Sounds fun. I am here holding down the fort. Meanwhile, let's go. Let's see what's going on with Judge Meineke.
Yes.
Looks like this is case number 24B02426. Ms. Catalan, looks like you had a conversation with the prosecutor, and they're going to reduce the original charge to impeding traffic. That's a non-reportable civil infraction, just carries with a fine. I just want to confirm that's what you want to do?
Yes.
All right, so to the charge of impeding traffic, do you plead responsible?
Yes.
Okay. I'll accept that plea. The original count is dismissed. And the fine on this is $175. If I give you 2 weeks to pay, is that enough time, ma'am?
Yes. I'm curious, and I don't know if you're the person to ask, the address that's going to be, or can I pay that online, or is that?
You can pay it online.
Oh, okay, perfect. Yes, that should be fine.
Well, just to play it safe, I will say 4 weeks time to pay, and that way you can make sure everything is taken care of, but make sure it gets done before the end of the month, end of November, okay?
Definitely, I appreciate that.
All right, good luck
And
to
I
you.
should be able to find it by looking up my citation number.
Yes, but you actually, if you look it up, let me give you a phone number, just to be
Yes,
safe.
that'd be great.
Okay?
I'm ready when you are. 248
246
246
3675.
3675. Okay.
Yeah, you can call them anytime and they can help you with the payment.
Okay, thank you so much. I appreciate it.
All right, good luck. Take care.
Thank you. You as well. Bye-bye.
By the way, Barbara, thank you for the $5 super chat. Always appreciate that.
All right, Desiree Fair, 285-01450.
Yes.
Mr. Steinberg?
You couldn't hear me. I was muted. Desiree, I worked your case out as I said I would.
Yes.
When I interviewed you, you're going to plead to an amend charge called allowing an unlicensed driver to drive. That means you allowed yourself to drive, and impeding traffic. And Judge Meineke will, Judge, she was advised of her rights when I arraigned her, and we're ready to proceed.
We'll go right through all those things, and Ms. Fair, ultimately is your goal to get a full license?
I am working on it. I am just having a lot going on right now. The last 2 weeks, things have been a little rough at the house.
Oh, Ms. Fair, I don't need it done tomorrow. So basically what'll happen is I'll take the plea today, and then I'm gonna hold off on any payments, okay? And then I'm gonna get you into a program, and you and I and a couple of attorneys that we have will work together. And then once you get your license, all right, then I will reduce your fines and costs. But what I won't do is make you pay anything right now. I want, if you've got money in your pocket, I want you to pay for, whatever life challenges you have, pay for the written test, pay for the road test, do all those things. Then you'll come back and see me, and you've got a license. We all win. You get a reduced fine and costs, and we'll go from there. Does that sound like a deal?
Sounds fair.
Okay. All right. So please raise your right hand. You swear to tell the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
All right. Please put your hand up. Okay. Ms. Fair, can you read, write, and understand the English language?
Yes.
Can you hear and understand me?
Yes.
Have you had a full chance to discuss this with your attorney?
Yes.
And are you satisfied with his advice?
Yes.
All right. You're pleading guilty to two reduced charges. You're pleading guilty to one reduced charge and responsible to one reduced charge. Neither of them go on your driving record or your criminal record, okay? And once I accept your plea, then the original charges that would have gone on your record, they get dismissed, okay? All right, the charge of allowing a licensed person to drive is a misdemeanor, carrying with it a maximum possible fine of $500 plus costs and up to 93 days in jail, all at this court's discretion. Before you enter a plea, you should understand you have the right to represent yourself or be represented by an attorney. If you cannot afford an attorney, one would and has been appointed for you at public expense. You have the right to a trial, either by me or by a jury. At that trial, you have the right to confront, cross-examine, and question all witnesses brought against you. You'd have the right to have the court subpoena witnesses on your behalf. You'd have the right to testify if you wanted to, remain silent if you wanted to, and no one could say anything about you remaining silent. As you appear before this court, you're presumed innocent of charge, and your guilt has to be proven beyond a reasonable doubt. Ms. Fair, do you understand that once you enter a plea, you give up all those rights that I just said that you have at a trial?
Yes.
Once you plead guilty, there'll be no trial. You understand that?
Yes, sir.
Anybody promise you or threaten you in any way other than the chance to keep this off your record and the chance to get your fines and costs reduced? Other than that, anybody promise you anything?
Nope.
It's your own choice to do this?
Yes, I have been working on this, and it's one of my top things to work on. I have been trying.
Ms. Fair, I've got some good news for you, Ms. Fair. You only have one more ticket to pay off, and then you can get, then Judge Meineke's court, that program is going to assist you in getting a full license for the first time in your life.
Woo! I might have to go buy me a lottery ticket.
There you go.
All right.
I verified that with the city attorney, Your Honor, that she only has one more to pay off before she can go sit for the road test and all that.
All right, so Ms. Fair, directing your attention to August 25th. August 25th of this year, 2025. Were you in the city of Berkeley?
Yes.
And did you allow an unlicensed person to drive your vehicle, that person being you?
Yes.
And do you plead responsible to impeding traffic?
Yes.
Okay. Satisfied, Mr. Steinberg?
I am, Judge.
I too am satisfied. The police have the same. So what's interesting, so Ms. Fair, I don't want to put your full address in the record, but is the Crooks address still good?
Yes.
Okay, good. And I'm not going to put your full phone number on the record, but are we still good to reach out to you at 4368?
No, it does need to be updated.
Ms. Fair, do you know how to use the chat?
Yes.
Okay, can you chat your number? There'll be a recipient that says clerk.
Here we go.
The judge is going to chat you, and then you'll respond to that chat with the number. See, this way your number is not public, Desiree.
Yeah, it says
Just chat your number, and you'll see the chat pop up. It just popped up on my side. Chat your number to the judge, please.
All right, I got it.
There you go, Judge.
All right, perfect. So and can we text you on that number?
Yes.
So Mr. Steinberg, after he worked out this good deal for you today, he's actually done today. You'll have new attorneys that are specialty attorneys for our program, and they'll be texting you so that they can help you if there's any like roadblocks, anything that you run into and you're like, I don't know how to get around this, or I don't know how to solve this issue. They're going to be there for you while we try to get your license back. Now, I don't know. There seems to be an Ohio ticket, Ms. Fair, and I don't know if that's been resolved or not. Normally, if it was causing her problems, Mr. Steinberg, it would say. Normally, if that was causing her problems, because I don't see any tickets on her record other than an Ohio ticket. And it says it's a default judgment. Oftentimes, Ms. Fair, if I see that a case is a default judgment out of state, that out of state ticket could affect your ability to get your license in state. all right? But, Mr. Steinberg, for your purposes, when I see that, usually it says up in the upper corner, not valid. Hers just says not licensed. When I see that, that usually means there's nothing else out there. She just needs to go to the Secretary of State. So, Ms. Fair, what I'd like you to do, all right, when you can, all right, is make an appointment with the Secretary of State. And when you go in there, be prepared, with all your documents, your, birth certificate, all that kind of stuff. Go in there and be ready to take a written test, all right? And if for some reason they say, hey, no, we can't give it to you because there's this out-of-state ticket, then what I want you to do immediately is contact the court, and so our attorneys, and we can look into what's going on out of state. My belief is, my hope is, that this isn't gonna hold you up, and you'll just be able to take the written test. Now, Ms. Fair, what I would advise you to do before you go in, I want you to go online, I want you to Google Michigan Driver's Written Test Practice Test, because there's all sorts of practice tests that are out there. I want you to practice before you go in there, because Ms. Fair, I only want you to take the test one time. I don't want you to have to take it multiple times, okay?
Okay.
And so what on my end, the charge that you just pled to, I'm not gonna assess any fines right now. I'm gonna delay, I'm making a note to myself, delay all payments. And we'll set this for a review in 90 days, okay? So I'm giving you some time here to get it done. Now, once you go in there, and I'm sorry, Ms. Burke, we'll also send you a letter that explains our Operation Drive program. They'll give you phone numbers to call, all that kind of stuff, okay? So in the next 90 days, all right, I want you to try to make that Secretary of State appointment. I want you to try to get that written test done. If something goes wrong, I want you to call us. Just so you know as well, once you take it past the written test, you don't immediately get a driver's license. All right, they're gonna make you sit on that permit. They'll give you a permit, but they'll make you sit on that permit for 30 days, then you can take a road test.
Oh, okay, because I was kind of confused because they told me I had to sit on it for 90 days.
30.
But thank you for clarifying.
So Ms. Fair, it's 30, okay? So I'll see you back here in 90 days. Don't stress, don't think, if you only have a permit, you don't have your full license, don't think you're gonna be in trouble. Just come back and give me an update. If I have to give you more time, I will, okay?
Okay.
All right, Mr. Steinberg, thank you for your efforts on Ms. Fair. Ms. Fair, we're gonna get this done. We're gonna get that license, okay?
Yes, thank you.
All right, good luck.
Thanks.
All right, thank you, Your Honor.
Morning, everybody. It's the Courtroom Files Live. It is a Thursday. Thank you so much for hanging out with us here. Take some time if you want to chat us up there on the chat and hang out. It's a great community. This is the best community in all of LawTube. And I'm not just saying that because I'm sitting here as a fill-in host and as a part of this community, but I mean, I really do believe that this is an amazing community. Maybe not the largest yet, just a little over 27,000 subscribers, but we are building something glorious here. All right, let's keep it going. We'll head over to Fulton County. Let's see what's happening over there this morning. Fulton County State Court.
Negotiated plea. Good morning, Mr. White.
Good morning, Judge. It is.
Okay. Good morning, Mr. Fuller. I'm Judge Eric Morrow. This is the state all-purpose calendar. Will you raise your right hand for me, please, sir? Do you swear or affirm the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can place your hand down. Thank you, Mr. Fuller. Yes, Ms. Evans Battle.
Yes, Judge. In this particular case, the state is asking for S account 1, 12 months probation, no further contact with the victim, Alicia Bent. Restitution, we'd ask for at least 30 days in order to determine the amount of restitution that she would be seeking, if any. Count 2, that she it's a 12 months to serve 48 days. Credit for time served, balance probated, probation. asking that it run consecutive to count 1. Count 3 is 12 months to serve, 48 days credit for time served, balance probated, no further contact with the victim, and the FGIP to run consecutive to count 1. And ask that he stipulate to identity, venue, and a factual basis for the plea. As to the other case, which I believe is an FTA, we would null pros that case. Thank you, Judge.
Right.
Your Honor, we're in agreement with, as far as the timing, and the family violence and all of that. We would just ask that it be a no further violent contact. They do have a child together, that has autism. My understanding is that Ms. Bent has been in contact with the court in previous situations and with the state prosecutor's office, and she wants contact. So other than that, and we would just ask probation, especially after the first year terminate if he's completed all of his requirements.
Battle.
At this particular time, we have not had contact with the victim on this case, and they attempted to reach out to her and have not been able to say one way or another, which is why we asked for the no further contact.
And Judge, we would argue that no further violent contact would give the same cover. Either way, he's coming back to jail.
Has anyone spoken with Ms. Bent?
I attempted to call her yesterday afternoon, was not unable to reach.
Okay. Well, for now, I'll go with the no further contact. If someone contacts her contemporaneous, I wouldn't mind modifying this. I want someone to speak with her first. Is there a reason that these are all running consecutive as opposed to concurrent?
One over. No.
3 years seems to be a long time for these charges.
Judge, I had 2 years. I'm not sure if that's.
And it's my understanding that it was 2 years as well. I may have misspoken, but, and I understand when reading this how it looks, but the expectation from the state would be that it would be for 2 years.
Okay, so if he completes, once he completes the terms of the probation, I'll have it go non-reporting the second year. Okay.
Thank you. And Judge, could we
Yes,
have at least like a third-party contact since they do have a child together?
Yes, third-party transfer contact for transfer of the minor child. Okay, anything further before I take the plea?
Definitely depends, Judge.
Okay, if not, Mr. Fuller, it's my understanding that in case 25 CR 002437F, you wish to plead guilty to criminal trespass and 2 counts of simple assault, family violence. Is that correct?
Yes, sir.
Say it again.
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
No.
You've been represented by counsel. Are you satisfied with his representation?
I guess, yeah.
You understand that you have a right to a trial by jury on these charges, and that by pleading guilty to them, you're giving up that right?
Yes, I'm trying to get home with my kids.
Has anyone forced you or coerced you to plead guilty?
No.
I'll accept the plea as negotiated, Mr. Fuller. Good luck to you, sir.
Excuse me, Judge.
Thank you, Ron.
Is there a stairway? Because they have a stairway on this, and we need the names and the stairway addresses as well on these recommendations. So it's a stairway. Is there a stairway or is it not?
It's my understanding that there is a stay away, and for now, there's a no further contact. I believe the
stairway address.
okay.
The address that I have is 808 Belcourt Parkway.
You don't stay there no more.
Just, then it's not a problem to stay away.
Okay, I believe back to position number 37 with Mr. Taylor. You've had an opportunity to speak with him, Mr. Majeski. What would you all like to do this morning?
So we want to enter a plea, Judge. We're in agreement with everything the state offered. I just want to talk about the 24-week anger management. That's all.
Okay. Let me, does he have a history, Ms. Washington?
What position, Your Honor? I did not catch this position.
Oh, that's fine. Good morning. This is position 37, Paul Taylor.
Okay, give me one moment. There are 7 arrest cycles. There was a 2019 misdemeanor conviction, pretrial diversion program for simple battery, family violence, and that appeared to be no priced. There was also a 2012 felony conviction for theft by taking, 2010 felony conviction for theft by conversion, and first offender treatment in the early 90s, but nothing further.
Okay. Ms. Evans Battle?
Yes, sir. In this particular case, the officer was called to the location. It appeared that the parties were in the process of going through a divorce. And he became upset because he was there he became upset because he saw that there was a birthday card from another young man to the victim. Her name is Taylor, and he pushed her into a television. He began choking her. He pushed her into a window. There were no marks on her, but the house was observed to be in disarray. That was consistent with her version of events. And although he indicated that it was the other way around, that she became upset because she realized that he was seeing someone else or saw a text or some message from someone else. There was a lethality assessment completed as well in this particular case, which indicated that there was some concern about the severity, because this was not the first act of violence in her particular case. So that is the reason for our recommendation for the anger management to take place.
Would you like to, would you go ahead and put the rest of the recommendation again on the record for me?
Yes, Your Honor. It's count 1, 12 months served, 36 days, credit for time served, balance probated, complete the FVIP program, no further violent contact for the purposes of third-party exchange. Stay away from 1157 South Avenue. Count 2, 12 months, 36 days to serve, credit for time served, balance probated, 24 weeks of anger management, 40 hours of community service to run concurrent with count 1. To stipulate to identity, venue, and a factual basis for the fee. Wow, at this point, I've put that on the record, so.
Thank you. It's my understanding that, I mean, there are 2 counts of simple battery family violence. It's my understanding that the FVIP is compatible with a family violence charge, given his history, and that he will be required to do FVIP. I'm not going to require him to do the 24 hours of anger management. So I would accept the state's recommendation, except for the 24 weeks of anger management.
That's fine.
Mr. Majeski?
The judge will accept that.
Okay. If nothing further, good morning, Mr. Paul. I'm Judge Eric Morrow. This is the state all-purpose calendar. Will you raise your right hand for me, please, sir? Do you swear or affirm the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. You can place your hand down, Mr. Taylor. You've been charged in case 24 CR 006938E with 2 counts of simple battery family violence. It's my understanding that you wish to plead guilty to those counts.
Yes.
Are you under the influence of any drugs or alcohol this morning?
No.
You've been represented by counsel. Are you satisfied with his representation?
Yes.
You understand that you have a right to a trial by jury on these charges and that by pleading guilty to them, you're giving up that right?
Yes.
Has anyone forced or coerced you to plead guilty?
No.
I'll accept the plea as negotiated, Mr. Taylor. When you complete the terms of the probation, I'll have it go to a non-reporting status. Good luck to you, sir.
Thank you.
You're welcome. Anything further this morning, Mr. Majeski?
No, Judge, as much as I like spending time with you, I got Judge Eaton waiting for me. So can I be excused to go do that?
Yes, have a good day. Good to see you as always.
Thank you, Judge.
Who do we have next?
We can go with position 89, Davis. Come on, Davis. They haven't seen the back row.
This is also going to be a negotiated plea, Mr. White.
That's correct, Judge.
Very good. Good morning, Mr. Davis. I'm Judge Eric Morrow. This is the state all-purpose calendar. Will you raise your right hand for me, please, sir? Do you swear or affirm the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Yes, Ms. Evans-Battle.
Yes, as to count 1, 12 months probation, a fine in the amount of $300. As to count 2, 12 months served, 10 days, credit for time served, balance probated, fine in the amount of $1,000. I believe on this particular charge, there's the court should serve notice of suspension of his license. As to count 3, the state would move to null pros that case. As to count 4, we're asking for a fine in the amount of $350. As to count 5, the state would move to null pros that case. As to count 6, the state would move to null pros that case. This is a global recommendation with 25 CR 006656F on account of simple battery that occurred on October the 23rd of 2025. We asked for just to run concurrent. It's 12 months probation, serves 16 days credit for time served, balance probated, and 12 weeks of anger management, complete 40 hours of community service, no further contact with Shante Ford, stay away from 574 Cedar Avenue Northwest, and that would be our recommendation. We ask that he stipulate to venue, identity, and a factual basis for the plea.
Right.
Your Honor, that is our understanding. We just ask that you accept the plea as negotiated, and we would ask that his probation terminate once he completes all of his requirements.
Mr. Davis, is anything further, Mr. White?
No, Judge, I'm sorry.
Okay.
I got something to say, sir.
Okay, you have a right to remain silent, Mr. Davis. Anything you say can be used against you. If you need to speak with Mr. White regarding the terms, I'm happy to allow you to do that, but you might not want to say anything in open court here. Mr. White, how would you like to handle this?
Is your question about anything other than what we talked about?
Yes, it's about the keep away order. I don't want to like no further not no further contact, but no violent contact in this matter.
Well, we discussed this yesterday. That wasn't brought up. You're going to have, Judge, I'm going to need to speak with him.
Okay, Ms. Evans Battle, have you talked to Ms. Ford in this matter? Has your office?
Let me
spoken to-
check again. I believe that there was some contact at the original bond hearing. Oh, hold on.
The audio is still there. They're just looking through records. It's the Courtroom Files Live. It's Thursday. We are in Fulton County State Court. Eric Morrow. And we'll hang here for just a little bit longer, and then we'll
Judge, I'll read my.
get some other places to go.
There was some contact from the victim in this particular case. She indicated that this was the first physical altercation that had taken place, but he is very abusive verbally and degrades and belittles her frequently, that she does not feel safe. She would like to not have I don't think she doesn't want him in the home. He's drinking and drug habits. She believes he maybe have an addiction to meth and alcohol.
Okay, so that's enough for me, Ms. Evans Battle.
Thank
Given
you.
that there has been contact with her. The court ordered no further contact at this time. So do you still need to speak with him, Mr. White?
Judge, I can just ask him if he still wants to go forward.
Yes, that means I don't do no more time. I get out. and leave.
Yes, we discussed, yes.
Okay.
Okay, so let me just be clear that no contact means absolutely no contact, Mr. Davis. Obviously no personal contact, but no phone contact, no contact whatsoever during the course of this probation.
But I have my truck's there, my clothing's there. I got a bunch of stuff there.
Okay, I'll give you a one-time police escort to go retrieve your belongings, okay?
Yes, sir.
All right, so we'll make that part of the sentence sheet. Anything further before I take the plea?
No.
If not, Mr. Davis, it's my understanding that in case 23 CR 005868F, you wish to plead guilty to willful obstruction of law enforcement officers, driving while your license was suspended or revoked, and no insurance. And in case 25 CR 006656F, you wish to plead guilty to simple battery. Is that correct?
Yes.
Are you under the influence of any drugs or alcohol this morning?
No.
You've been represented by counsel. Are you satisfied with his representation?
Yes.
You understand that you have a right to a trial by jury on these charges and that by pleading guilty to them, you're giving up that right?
Yes.
Has anyone forced or coerced you to plead guilty? I'll accept the plea as negotiated. Mr. Davis, I will give you a one-time police escort to retrieve your belongings. I will have the probation go to a non-reporting status when you complete the terms of the probation. And it's my understanding that position number 9, the failure to appear, is going to be null crossed. Good luck to you, Mr. Davis.
Thank you.
Your Honor, Miss Bent is online. She is the alleged victim in the 13 and 14 that we handled earlier.
Yes. Ms. Alicia Bent, if you would like to address the court, now is your opportunity to do so, ma'am. If you can come on camera for me and unmute yourself.
Good
Yes.
morning.
Good morning, ma'am. Thank you for being here. Can you raise your right hand for me?
Yes.
Do you swear or affirm the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth?
Yes, Judge.
Okay, and you can place your hand down. In Mr. Fuller's case earlier, we were wondering whether or not you would like to have contact with him.
Yes, please.
Okay, has anything like this happened in the past?
No, and we did go through counseling with our school, my son's school. We haven't had an issue since then, so I'm just hoping we can get back to some kind of normality with the co-parenting.
Okay, very good. So I'll have it that he had no further violent contact with you, ma'am.
Thank you so much.
You're welcome. Thank you. Do you have anything, Mr. White?
And Judge, just to be sure, removing the stay away as well.
Okay, so no further violent contact, and there won't be a stay away. Did you get that, Ms. Grace?
Yes, sir.
Okay, thank you. All right, Ms. Bent, thank you so much for being here. Have a good day.
Thank you, Your Honor.
All right, a lot happening in Fulton County. Maybe we'll check back in there. We've got people being thrown into windows and televisions and domestic stuff and co-parenting issues, all sorts of things happening down there. My goodness. All right, well, let's head up north. Let's see what's going on up in Wisconsin this morning. Oh, yeah, let's see what's happening with Judge Morgan. Yeah. Okay. Every time we go to Wisconsin, something gets messed up with the audio there. Oh, yeah, for sure. Well, let's see if we can't fix that there. Oh, yeah, you betcha.
We have his counsel, Glenn Keene, also by video. We're set here today in this matter for a status conference. Mr. Keene, can you please update the court?
Yes, Your Honor, we've received an offer and I'd ask for a status conference in a couple months. The reason for that, Your Honor, and for the DA's office is because since the last hearing, Mr. McCarthy has been working to find a VA inpatient substance abuse treatment center, and he has to clear up a couple of bond cases in Minnesota. So we're hoping that within the next month or two, he'll get admitted to that inpatient substance abuse center, and hoping that that might affect the ultimate outcome of the case.
And okay, so how long is he in custody?
Your Honor, I can't answer that because he's waived extradition and has to go back to a couple of counties in Minnesota. Washburn County, where he's on a cash bond, it sounds, with the DA and the prosecutor, it sounds like they'll be okay changing that to a signature bond if he's given an inpatient bed at the VA. But he has to go back to Minnesota and clear up 2 court cases. I don't know how long it'll take them to pick it up. That's why I'm thinking a few months, 2 to 3 months would probably be a reasonable time frame.
Okay, yeah, he has posted cash here. So I am going to remind him that, Mr. McCarthy, you have $1,000 cash posted. That is a lot of money to lose. And so you must make all of your court appearances. And if you are to, or you want to appear by video, because if you're in custody or in treatment, you must have the court's permission and authority to appear by video before you do so. You can't just go, I'm in treatment, I'm in custody, and I'm going to appear. Do you understand that?
Yes, Your Honor.
All right, so let's get a status. All right, and this is Mr. Vila's case. how about Monday, January 5th at 9:15?
That works for defense, Your Honor.
All right, and I'm going to tell you right now that because this is pushed out a couple of months, that I am going to want to see if there is actually movement in what's happening. Because I don't think that this is a very serious, well, it's a very difficult case or complex case. And so I want to make sure that we can keep everything moving, okay? All right, anything further from either side?
Not for me, Your Honor.
All right, thank you. Then we are adjourned. Thank you, Mr. McCarthy.
Thank
Please
you, Your
keep your attorney posted on all of the things that you're doing, and if you are being moved here to there, okay?
I will, Your Honor. Thank you.
And while we're off the record, I would note that Mr. McCarthy's done a very good job of that. He's let me know the VA contact. I've been able to contact him. So Mr. McCarthy has done an outstanding job of trying to keep things moving since he's come back into custody.
I'm glad to hear that. All right, Mr. Gephardt. We will go on the record in the matter 25 CM 166, State of Wisconsin versus Brett Gephardt. The state appears through Assistant District Attorney Jose Fila in person. Mr. Gephardt appears in person with his counsel, Glenn Keene, by video conferencing. We're set today in this matter for a status conference. Mr. Keene, please update the court.
Yes, Your Honor. Before last hearing, I had sent around the last hearing, I made an offer to AD Avila, and he's confirmed to me that it's acceptable. I tried contacting Mr. Gephardt via phone this morning to go over the offer, wasn't able to reach him. So I'll just present it on the record, and my advice is that he take it. What it calls for is an offer to resolve it, where if Mr. Gephardt takes and completes the domestic violence education course with Dave Hatch, and completes it, obviously, the county would be willing to reduce it to a simple citation for $330.50. I did provide Mr. Gephardt the information the court has last time. I don't know if he still has it, for how to reach Mr. Hatch, how much that would cost, and how many hours of time it would take.
All right, so do you understand the offer, Mr. Gephardt?
Yes, I do.
And do you still have that information about Dave Hatch?
Yes.
And his program, and I think it's $150 you have to pay for that program.
Yes.
Is that something you wish to entertain?
Yeah, I'll do that.
Excellent. And so I'm going to say, contact Mr. Hatch as quickly as you practically can.
Okay.
And get that course going,
All
because
right.
the sooner you do, the sooner this can get resolved. And if it is going to be resolved through that process, which would be amended to an ordinance violation, you may not even need to come to the next court hearing, because the state can do it through paper. All right.
Okay.
And you have $250 posted in your cash, as bail. I'm going to tell you that if you're telling me right now that you're going to accept that offer, and I'm telling the state right now for paper purposes, if that's what it's going, I'll simply, from the court's perspective, accept $250. I'll waive the rest.
Okay.
Okay?
Yeah.
Because you're going to have to pay for the class and do those things.
Yep.
So I'm satisfied that, you know, you're getting what you need, and the community is going to be safe and all of those things. So I'm going to give you a little bit more of a benefit of waiving those extra fees.
Thank you.
Okay. All right. So I'm going to schedule you for that January 5th date, January 5th at 9:15. Again, if you complete the class, the faster you complete it, let's say you complete it in December and there's proof to the state, you won't need to come to that next hearing. Okay. Come get your notice and then you are free to leave.
All right. Thank you.
Thank you.
Thank you, Aaron.
Thank you, Mr. Keene.
It's the
All right,
Courtroom Files
I cannot
Live.
see the jail right now. I'm guessing it's Miss Honeycutt.
We are here on a Thursday hanging out with Judge Mogan for a little bit. And then we'll see what else is going on. Courts are kind of picking up from where they were earlier this morning, so we have a few places to go if need be. Who knows? Maybe we'll check in, see if it's hangry time down in Miami-Dade in a little while. Just a little tease of what could be coming up.
Attorney Kevin Schmidt in person. Ms. Honeycutt appears by video conferencing in custody in Burnett County Jail. We have her counsel, Tripp Stroud, appearing by video as well. We're set for bond modification hearing. The court has received the petition and motion filed on behalf of Ms. Honeycutt through counsel. I have read and reviewed that. Mr. Stroud, for the record and that purpose, can you please provide a brief argument?
Yes, Judge. Considering you've already read the motion, I'll add this on top of it. I think the concern expressed by the state was that they characterized Ms. Honeycutt as a flight risk because she has family in California. We're trying to address that and give the court that assurance and guarantee that the court will know her whereabouts at all times and that she won't be leaving the state and that she has a stable place to live. I'd also point out the fact that another factor for the court to consider is the nature of the allegations against Ms. Honeycutt. The allegations, it's a property crime. No one was hurt. No one was threatened with harm. And having Ms. Honeycutt in the community with those allegations on top of her would not be a risk to the community. I think the bond conditions meet the need and concern expressed by the state. And so I'd ask the court to agree to lower the bond, and that if Ms. Honeycutt is able to make bail, impose the conditions that I proposed, the electronic monitoring and then the geographic restriction not leaving the state. Thank you.
Mr. Stroud, thank you for your argument. And I just wanted to update you because, again, I did read your motion. The court does not and would not grant electronic monitor through a private party. The court has its own program that does that, and that is $30 a day, not $14.
Okay, well, I think the willingness to on the part of Ms. Honeycutt's family, I think, would remain the same. I just have to double check with their budget to make sure that they'd still be able to do that. And of course, that would be a condition that she, condition precedent to being able to leave the jail. So if they can't do that, then she can't meet that condition. So thank you for pointing that out.
I just wanted to make sure that you knew that. Mr. Schmidt?
State's position is bond should remain the same. This is the 6th time in 5 months we've addressed Ms. Honeycutt's bond in court. We've done it on May 28th, June 3rd, June 9th, July 9th, August 27th. Not a single thing in the motion or said today is any different than anything said in the past. In fact, Ms. Honeycutt's previous counsel also offered to do the court's $30 a month electronic monitor back on July 9th. So that's not even new. So I know her family would be willing to foot it because she's already said that they would on July 9th. The reason we haven't changed bond is because she is a flight risk. And this is not a safe crime. Burglary is a crime of violence, not just by statute, but because of the risk it imposes on people when you do it. The reason the court's been keeping the bond high in this case is because of the strength of the evidence, the seriousness of the charge, and the likelihood of the offender to flee given the certainty of punishment because of the strength of the evidence. Again, for the 6th time, this is a person who's accused of having told the police she had no reason to be where this safe was taken from and had never been there. Then her DNA was found there. Then her cell phone put her there. She, on her phone, showed she had been in contact around the time of the stealing of the bank safe with one of the only people who knew where it was. We've now recovered some of the stolen property in possession of somebody with a connection to her through her boyfriend. The evidence is so strong in this. It is a crime of violence. At this point, I have to let the court know, like, the victim has expressed distress to us that she keeps having these bond hearings. He's terrified she's going to get a bond reduction, leave, and never come back. And the ECM does not help prevent that. The ECM, if you're out and it's on you, you just cut it and run. Like, that's how that would go. By the time anyone could get out there, she'd be long gone. It does not extinguish the threat of her running. Thank you.
All right, thank you. Where are we in terms of the case? Is it looking like it could be a potential resolution? Are we looking like we're going to trial, Mr. Stroud?
It's looking like we're going to trial.
All right. So we're probably, and right now you have not initiated speedy, but I'm going to guess that this is something that is going to want to be on my calendar as quickly as we practically can. How many days do you think the trial is going to be, Mr. Schmidt and or Mr. Stroud?
Well, let me see. We said it once before.
Yeah, I can't remember if it was 4 days.
I think 4 days. I was going to say 3. If we set it for 4, I think that would be sufficient and appropriate.
And we do need an analyst though, so we would need to call and get an analyst.
And it's 2 analysts because we have MLCIC. They're the ones who did the cell phone stuff.
That's right.
And now we have a Minong Police Department in Douglas because they were the ones who recovered the property in possession of someone with a connection to her.
All right. I do understand the request and the request for the bond modification, and the court does need to take in consideration the weight of the evidence that has been argued to the court in a bond modification request. And also the arguments that have been made by the state at multiple hearings with regards to her connections elsewhere. And I believe at one time that I don't know if she didn't really abscond, because I believe she doesn't have a significant criminal history, but that I thought she went to California and or why am I thinking Dakota?
She was in South Dakota when she learned that these charges had been filed, and she returned and appeared. I believe their arrest warrant was issued, and the state can correct me if I'm wrong because they've been with the case longer, but I believe an arrest warrant was issued, and when Miss Honeycutt learned about it, she came back.
I do recall that, and that went into her favor as to why the court did modify bond from the higher cash down to the $15,000 because she did voluntarily turn herself in. At this time, based upon the arguments that the court has heard, I'm going to deny the modification request. If you look at the monitor, she would be paying, her parents would be paying almost $1,000 a month to have her on monitor. And granted, that money does go into the court or the county's justice fund, and it covers the expense plus the time of the employee who monitors. But that's a lot of money that could go towards posting of the bail if that's what she is looking for. But at least at this time, the court is going to deny the request. And if we're looking at getting this on the court calendar for a trial and to have it as soon as possible, whether it is a speedy request, we're going to need to do that. And we're going to need to have the analysts, both of them, be a part of it or get dates that work so that we can ensure that they are number ones.
Should we try to do that now, Judge?
I can't do that with 2. This had to be
MOCIC, I can't get on the phone like lab anyways, so we
Yeah.
just want to do lab.
Wasn't this the case though that your office had to schedule because of the 2 people? I believe you did.
Other cases, what we've done where there's been MOCIC and DNA, we've just set the DNA. And then if we know there's going to be such and so many days, like 3 or 4, the odds it won't work for MOCIC is very low.
All right, we can go ahead and schedule that right now if you wish to, Mr. Stroud. Off the record. Okay, Mr. Schmidt, what is the, oh, we have Denise Jones. I took a note of that. And I have the M number. So, but I don't recall what number it was that I need to call.
Oh,
Is it the crime lab?
let me find it. It's on there. I know it'll be one of the 2 crime labs.
be Madison. Is it the 2031 number?
Nope, I think I found it. It is, yes, it's the Madison lab, so the last four digits are the 2031, you're right.
Hey, crime lab, please hold.
While we're on hold, let's see if we can, let's see if we can, I did that, I hit a button,
That is an absolute bop on that Crime Labs hold system.
or at least that
Thank you
works
for
with
holding.
you.
How can I help you?
Oh, well, they're back. All right. Hi, this is Judge Mogan in Burnett County.
Hi.
Hi, I need to schedule a jury trial with Denise Jones.
Okay.
M number 24-960.
And then for which date?
And hopefully I'm trying to schedule with the lab as well as the defense attorney right now. So he may say it doesn't work or whatnot, but we're going to figure it out. I have February 2nd, 3rd, and 4th.
I think they asked what case.
Oh, what case?
It's
No
M,
date as well.
oh, it's M24-960.
I gave that.
Oh, sorry.
All right. So
It looks like Denise is available the February 2nd, 3rd, and 4th.
all right. So does that, Mr. Stroud?
No, Judge, I'm scheduled for a trial that week. I would say my calendar is pretty full till April.
I could do March 31st, April 1st, and April 2nd.
Denise is available for all of those.
I am on vacation that week with my family, the last week in March.
Okay, that's fine. I could do April 13th, 14th, and 15th.
That works
Denise is available
much
for all
better.
of those.
That works, Mr. Stroud?
Yes, it does.
All right, let's get it scheduled for April 13th, 14th, and 15th.
And then one question for you, or two, I guess. What is the court case number?
The court case number, my 25 CF41 number?
Yep.
Yeah, 25 CF41.
And then can you confirm the defendant's name?
Heather Honeycutt.
Judge,
I have Denise as your number. Oh, sorry.
Sorry, Mr. Stroud.
Judge, I'm terribly sorry. That week actually doesn't work for me either.
What about, that's fine, April 27, 28, 29.
She's available, but she'll be your number 2 under Oconto.
That week works for me.
Well, I'm willing to take the chance. So April 27, 28, and 29, we'll schedule it for then.
All right, Denise is reserved for you for all 3 days.
Excellent. Do you need to contact the district attorney and his number?
For us, no.
Okay, excellent. Thank
We
you
just
so much.
Yep, we just need a subpoena.
All right, they will make sure they take care of that. Thank you so much.
Yep, of course. Thank you.
Bye.
Bye.
All right, back on the record, same appearances as previously noted. The court is going to schedule the jury trial for April 27, 28, and 29. We're going to get a final pre-trial. Can you do, Mr. Stroud, March 26, 9 in the morning? Video conference will be fine.
Yes.
All right, 9 a.m., March 26, final pretrial. We currently still have a status conference on January 14 at 3. Are you looking at keeping that, Mr. Stroud?
I think we can take that off now that we've got a trial date.
I am going to then set another status for February, just in case, to see if the matter has been moving towards any resolution. Mr. Stroud, can you do February 26 at 9?
Yes.
All right, February 26 at 9 a.m. video status. And then we have the March 26 at 9 for final pretrial. And Mr. Stroud, I don't know how it is where you normally practice and what you do, but I'm telling you this as well as Ms. Honeycutt so she can be aware. This court's final pretrial is what I call my drop dead date. I will not accept any agreement, any at all, after the March 26th date. It will go to trial. The only way that it will not go to trial after that date is if Ms. Honeycutt pleads guilty to both of those charges, or if the state dismisses them, okay?
That's fair, Judge, and similar to how many courts do it where I practice. So
excellent. I'm glad to hear that.
Too. Good.
Thank you. Mr. Schmidt.
I think I want to check with Attorney Stroud because it's much easier to address now than later. I think 3 days is enough. You said 4. Do you think 3 is enough?
I do.
Okay, never mind then.
Okay. All right, then we are adjourned. Thank you. And if anything comes up prior to any of the dates we have, if the matter resolves or something else and you need to be in front of the court, Mr. Stroud, just call and my assistant will get you another date to be heard, okay?
All right, thank you very much.
All right, it's the Courtroom Files Live. It is a Thursday, and thank you so much for joining me. We're visiting with Judge Mogan up there in Wisconsin. Now let's head down to Texas. It is our commitment to give you 9 to 11% more Judge Boyd. So with that having been said, here's Judge Boyd.
Sweating. I couldn't wear a robe. I was constantly apologizing. I'm like, it's so hot in here. So you're ready on Lampkin? Yes, sir. All right, Mr. Lampkin, if you'll come up, please.
Oh.
Hello.
Of course.
All right, so what are we going to be doing with this case?
So we spoke with the family. I believe we were going towards contested NTR where we wrap the cases up that way. We have been filing it.
Okay. All right. Ms. Ferguson, can you state when will you be ready on a contested hearing on Mr. Lampkin? All right, if you'll give me a 2-week reset. And are parties okay with witnesses appearing by Zoom?
Yes, Your Honor. We are going to be in trial in both Bear and Kendall over the next 2 weeks. Would it be possible to have a date closer to 3 or 4 weeks now?
State?
Yes.
Defense say they will be in trial in 2 weeks in another county, Bear County, and then someplace out of county. Are you okay with moving it to 3 weeks out?
Yes, Your Honor.
All right, thank you. All right, Ms. Ferguson, a 3-week reset for contested hearing.
Day 3.
Yes.
We're gonna be doing our mistrial for punishment in the 290th on the 17th. So I think the 20th would be best for us.
All right, November 20th. Yes. All right, so continue taking your medications, following the doctor's orders. You understand? All right, and listen to your grandfather. And counsel, I believe everything has been signed.
I don't believe so, Judge. We just have the motion to allow him to go trick or treating with his family around his neighborhood.
All right,
State is opposed.
all right. State, do you want to be heard on the defense's request?
Or, oh, the trick or treating,
Mhm.
Judge, I mean, we're not in agreement on that, but.
Do you need a hearing?
No,
or-
you could just notate that.
All right, so this is what I'm going to say, and I know the state is aware of this. Because of his mental health issues, he's always with his grandfather, and if his grandfather is going to be out of the house, it's best for his mental health, and the court is going to find it best for the safety of the community that he is with his grandfather. So, can I have the grandfather come up, please? All right. Sir, I know that, good morning. I know that you're responsible for other people in your household as well. With regard, you're responsible for him.
Yes.
All right. So with regards to this, going to different neighborhoods for trick or treating, why is that needed for him?
It's only because where the relatives live, one uncle lives in Camelot.
Mhm.
And then we go by the church on Judson Road.
Mhm.
And so they do that trunk or treat.
Mhm.
And so we go to the church and then we go to where his uncle is in Camelot. So it's about like 30 minutes away.
Mhm.
And then there'd be all the little kids and stuff like that, you know.
Okay, so why does he need to go? That's what I'm trying to figure out.
Oh, because the family all goes together. And like,
Ah,
you know, like the church has that hayride thing
yes.
where you sit on it and. they pull
Okay,
it.
I understand now. I thought that you're taking him, because sometimes I see adults trick or treating and they don't have a child with them, and I'm like, come on. This is not for you. But now I understand.
And plus, Your Honor, there's a new, he's a uncle, there's a new grandbaby.
Mhm.
Oh, that's all.
All right, so are you dressing for the festivities?
Am I?
Be in a
Yes.
costume.
Oh, no, I'm just going as my old military style look.
So State, I understand your objections, but I also,
Your Honor, I went as a sheik,
when as a what?
SHEIK.
Ah.
And I had two ladies go with me, kind of the sheik and him. Oh, I just thought I'd tell you that.
Okay.
That's right. I'm sorry. Oh, too much.
Yeah. All right. So this is what I'll do. I understand his mental health issues. And because we've had so many hearings with him before with probation, and we've had previous input from his doctor, I understand this is what he needs to maintain his mental health. So I will grant it. However, he can only do this if you are present.
Oh, yes, I'll be present.
All right. So if you all will add that, and I will sign it.
Thank you, Judge.
All right. And then Ms. Ferguson, if you'll have a seat, Ms. Ferguson will give the reset form, and once you sign that, you'll be excused.
Thank you, Judge.
Yes, just have a seat. Yes. Thank you.
Thank you.
You're welcome.
I want to take this opportunity to thank Barbara in the chat for gifting a membership, and Grandma TCF, Mama Joan, with a $10 super chat. Thank you so much for that. Of course, the super chats and the super stickers, while I am filling in for Dan, those go to me. All of the channel memberships, well, those go to the channel. Those go to Dan and the channel, keeping up the maintenance on this fine community. So keep that in mind when you're in our chat hanging out. Of course, if you just want to hang out, that's cool too. We'll continue here with Judge Boyd for a little bit, but I I'm going to monitor. I'm going to see if it's getting to be hangry time down in Miami-Dade here. I think we're going to go there next. So, but we'll see what else comes up too. There's a lot still going on in the courts right now. Let's get back to Judge Boyd. Boyd, oh Boyd.
Adam, are you ready on your issue?
Yes, Your Honor. We have
Who is your?
Damian Antonio.
All right, yes. Damian Antonio? And Adriana, I'm just doing him because he has to go for a jury trial.
Thank you, Judge.
Yes. All right, yes.
So, Judge, we have conferred, I believe we have all discovery, and we actually have a new offer, which I'm going to talk to him about. I think there's a good chance we're going to have this thing resolved before our next setting.
All right, Ms. Ferguson, if you'll set this for a plea deadline date in 2 weeks, please.
That should work.
All right, thank you. Just have a seat. Once you sign the reset form, you'll be excused. You're welcome.
All right.
Just 1 minute. Thanks, Judge.
You're welcome.
The 19th is the party in here, right?
Yes.
Yeah, the 12th is in the 186. It's okay. So
Little adjustment here because I think we're going to go to Miami-Dade. Do we dare? Do we dare see if it's hangry time down there or not? I don't know, but regardless, I guess we'll do it. Let's see what is happening. The audio can sometimes be sketchy. It can often be a touchy situation down there, but let's go to Miami-Dade. And let's see what's happening.
It's from October 19th.
With, if I can get this to go. Oh boy. Well, I just broke it. Actually, Judge Glazer just broke it. We're trying. One moment. All right. Don't worry, this is a professional live operation, boys and girls. How long have I been doing this? Oh, I don't know. 10 seconds, 10 years. Who knows how long? All right. We can do it now. Here we go. Here is Judge Glazer. Of course. Oh, there we go. Or not. Okay. Let's try. I'm telling you, I swear we've done this before. All right. All right. Judge Glazer, you're making a mockery of me right now. I don't appreciate it. Okay, here we go. For real this time. Oh, come on now. She's reading right now, so that's why you're not hearing any audio.
Good
But
morning,
there we go.
sir. You were arrested for felony battery and grand theft. I will appoint the public defender's office for you. So it's from August 25th. Are you still living with the victim, your brother? Do you live with the victims?
Ever since.
Say yes or a no. Are you two living together in the same house? Do you live with Ricardo Sarmiento?
No.
I just need to know for the same in order to read to you. So he punched his brother in the face. Victim had to get 30 stitches to close the laceration on his forehead. Probable cause for aggravated battery. He also took the victim's ring that was valued at $5,000. There's probable cause for the charges. You are ordered to stay away from your brother, Ricardo Sarmiento and Raven Brooks. No contact with these alleged victims, either directly, indirectly, in person, in writing, by telephone, or through third parties. No contact with the victims through social media or other electronic means. And you must stay at least 500 feet away from the victims, their home and school, and place of employment at all times. Do not engage in any criminal activity. Do not use or possess illegal drugs. Do not use, purchase, possess, or carry a firearm, gun, weapon, or ammunition. You must immediately surrender any firearms, ammunition, and any concealed weapons permits to the nearest police department and file a receipt with the court. Do you understand the stay away order, sir? You understand? Yeah.
Yes.
All right. So I'll set bond it's aggravated battery, but I'll leave it a felony battery bond of $5,000. Count 2 grand theft is $2,500. Have a good day.
Thank you.
Next case we have is Daryl Fonseca, page 11. At a charge.
Buenos días.
Good.
Good morning.
Vale.
Usted necesita intérprete,
Sí.
¿verdad? Okay. He requires the interpreter, Your
Okay,
Honor.
sir, good morning. You were arrested for battery by a detainee on another detainee.
Agresión corporal hacia un preso por otro preso es el cargo.
I will appoint the public defender's office for you.
Le asigno la abogada de la defensa pública que tiene a su mano izquierda para que lo represente.
There's probable cause for the charge. Your bond is $2,500.
Tiene motivo fundado para este cargo. Su fianza $2,500.
Have a nice day.
Que tenga buen día.
Next, Christopher Everett, page 13.
On felony bonds.
Hold for F24-26921. Good morning, sir. You were arrested for aggravated battery on a pregnant victim and domestic battery by strangulation. I will appoint the public defender's office for you. Also, you're out on bond. Let me review the probable cause. There's probable cause for aggravated battery on a pregnant victim and count 2 domestic battery by strangulation. She's 23 weeks pregnant. He dragged her to the floor, slapped her, choked her. He threw her against the wall and a couch. So there's probable cause of beating up a 23-year-old pregnant victim allegedly. You are ordered to stay away from the alleged victim, Tamila Harrison. No contact with the victim, either directly, indirectly, in person, in writing, by telephone, or through third parties. No contact with the victim through social media or other electronic means. And you must stay at least 500 feet away from the victim, her home and school and place of employment at all times. Do not engage in any criminal activity. Do not use or possess drugs. And do not use, purchase, possess, or carry a firearm, gun, weapon or ammunition, you must immediately surrender any firearms, ammunition, and any concealed weapons permits to the nearest police department and file a receipt with the court. And sir, do you have to go to the victim's home to collect any of your personal belongings?
I think so.
Yes or no?
Yes, I think.
Or you may return to the victim's residence one time only within 48 hours of your release from jail. You must be accompanied by a police officer so that you can retrieve your personal clothing, health items, medication, personal and business related paperwork and work tools. If you go to the victim's home without the police, or if you stay there, you will be arrested. Do you understand the stay away order? You understand the stay away order, sir?
Yes.
All right, $7,500 bond count 1, 2,500 count 2, and you'll see the judge tomorrow. Have a good day.
10,000.
It's the Courtroom Files live on a Thursday. We're in Miami-Dade with Judge Glazer. It's approaching lunchtime there, so we'll see how she's holding up, especially with that audio she's got going on.
Sir, you were arrested for carrying a concealed firearm in possession of cannabis, 20 grams or less. I will appoint the public defender's office for you.
Yes.
Unfortunately, you're out on bond. There's a hold for F-24 20892.
Yes, I haven't been bitten from that charge. I just started.
You're out on bond. You got to see the judge tomorrow. This concealed weapons permit was suspended as well. All right. Count 1, carrying a concealed firearm is $2,500. Count 2, possession of cannabis, $1. Have a good day. Next, Dennis Watson, page 14. Good morning, sir. You were arrested for interference with custody. I will appoint the public defender's office for you. So I guess he's in a vehicle, was it a vehicle with 3 underage girls? One was a missing person. He picked her up yesterday and they went to the beach in Fort Lauderdale. And they spent the evening together. There's probable cause for interference with custody. The foster child. Bond is $2,500. Have a good day. You didn't give me a stay away order, Steve?
The A form didn't list the witness, the victims.
You better stay away from that young lady, sir, because if you get arrested again, you'll be locked up in jail until the trial. Give me one second. One second. Okay, good morning. This is Mr. Preston Johnson. So you were arrested, right, Mr. Johnson? That's Mr. Johnson. You were arrested for uttering forged bills, possession of counterfeit or forged notes, and petty theft 2 or more convictions. I will appoint the public defender's office for you. Well, the co-defendant bonded out. He's here. Is there Macy's?
Post.
Let's see. Both parties made transactions at Macy's using fraudulent bills. Mr. Jackson had made $539 of transactions using fraudulent bills. It was on CCTV. He had a large amount of fraudulent bills on his person, 56 20s, 1500s, and 250s.
Your Honor,
Yeah.
Mr. Johnson is telling me that he already paid his bond. Is there any way for us to verify that? I believe.
I don't know, he's still here. That's okay, I'm set the bond anyway.
Okay.
She'll say.
Count one, stay away from the Macy's at 19535 Biscayne Boulevard in Aventura, Florida. You're not allowed to go there. You got to stay away from there, okay? Also, the co-defendant bonds it out. You may want to contact your bondsman to see what happened. I'll set the bonds $2,500 count one, 2,500 count two, and 2,500 count three. Have a good day.
So that's 25.
7,500 total.
And Mr. Perez Castillo speaks Spanish.
What?
The next one, Walker refused, Your Honor.
Walker refused. Let me review. So there's probable cause for count one, count two, and count three.
Hay motivo fundado para el cargo. Are you,
Oh, it's
No,
are we talking
think
about
we're-
this defendant?
no.
No.
Person
Okay.
number two is not there.
Okay.
Right, so I'm resetting Mr. Walker's case for the refusal. This is a plea bar for Red Castillo. Morning, sir.
Buenos días, señor.
Hola.
Hello, good day.
Were arrested for aggravated assault with a deadly weapon, 2 counts.
2 cargos de agresión con agravante con un arma mortífera.
Also accessory after the fact, improper exhibition of a weapon or firearm.
Exhibir un arma de fuego ilegalmente y ser después de los hechos como encubridor
And battery.
y agresión corporal.
I will appoint the public defender's office for you.
Yo le asigno al abogado de la defensa pública para que lo represente.
It's a case from October 11th of 2025 where the victim was found suffering from stab wounds.
Octubre 11 del 2025 fue el día de los hechos.
Sí.
So public defender's office is appointed. Just please do not discuss the facts of the case because you're presumed not guilty.
Por favor,
Yeah,
usted
yeah.
tiene la presunción de inocencia. No hable de los detalles del caso, por favor.
What'd you say, corrections?
He has an immigration hold.
You also have an
Y
immigration.
también tiene una
hold.
orden
Looks like
de
it's-
detención por inmigración.
Okay.
Your Honor, Mr. Morin is here to substitute me.
So you're doing it right now in the middle of the,
No, I'll finish with this defendant, Your Honor.
okay. I don't know if we have any more. Are there any more people there? Any more Spanish speakers, corrections?
No.
We must more and thank you. We're going to be, we don't need you. We're almost at the end calendar, but thank you.
Mr. Morin, we're at the end of calendar. The judge says that we don't need any interpreter.
Oh, thank you. Thank you.
Thank
Thank you so
you.
much. Have a good afternoon.
Okay, Juan. Okay, bye-bye.
It's TCF Live on a Thursday. Michael Groff in for Dan Soul. We're just hanging out in Miami-Dade with Judge Glazer, who is very, very intently looking over documents. So we are here seeing where that goes. There we
Broke
go.
a glass bottle and attacked some two guys he doesn't even know. They
Muy
had a-
violento, agarró una botella y atacó a dos hombres.
There's probable cause. Setting up on count one aggravated assault, 2 counts of aggravated assault with a deadly weapon. I'm gonna set that at. It's not aggravated assault, it's aggravated battery. Why is it charged as aggravated assault? They cut these people, it should be a non-bondable one. Used a dangerous weapon to cut the victims out of the hospital.
Y dice la jueza que no sabe por qué dice agresión con agravante. Es golpiza con agravante. Las
I
personas
think,
tuvieron que ir al hospital.
I think they charged it this way because the video showed it was the other guy who did the stabbing.
Yo creo que lo cargaron así porque aparentemente, dice el fiscal, fue el otro el que puñaleó.
Oh, okay. I understand.
Ya entiendo.
Again, we didn't lose audio.
There's probable cause then for what's alleged here. Stay away from the alleged victim. Stephen Sweeney and Chris Johnson.
What was the last name for Stephen? I'm sorry, Your Honor.
Stephen Sweeney and Chris Johnson.
Tiene que mantenerse alejado de las presuntas víctimas Stephen Sweeney y Chris Johnson.
No contact with these alleged victims, either directly, indirectly, in person, in writing, by telephone, or through third parties.
No puede tener contacto con las víctimas ni directa ni indirectamente, ni por teléfono, ni en persona, ni por escrito, ni por terceras personas.
No contact with the victims through social media or other electronic means.
No contacto con las víctimas por medios sociales ni electrónicos.
And you must stay at least 500 feet away from the victims, their home and school, and place of employment at all times.
Debe mantenerse a por lo menos 500 pies de las víctimas, su casa, escuela y lugar de empleo en todo momento.
Do you understand the stay away order, sir?
¿Usted entiende esta orden de alejamiento, señor?
Sí.
Yes.
Thank you. I'm setting a bond. Counts 1 and 2 aggravated assault with a deadly weapon or $5,000 each count.
Cargo 1 y 2, agresión con agravante con un arma mortífera, $5,000 cada una.
Count 3 accessory after the fact is $5,000 for a bond.
$5,000 el cargo 3 por ser encubridor.
Count 4 improper exhibition of a weapon is $500.
$500 por exhibir un arma indebidamente.
In count five, battery is $1,000.
Y $1,000 por el cargo 5, agresión corporal.
Have a nice day.
Que tenga buen día. Gracias.
Next, Jack.
All right,
Ote,
let's
is he there?
switch away from
Your Honor.
Miami-Dade for a little bit. Let's take you back to
And he
Texas
refused when he wanted to go back.
and see what's going on down there. Judge Boyd's got another contestant coming on down, so
Saying no match found.
let's go to Judge Boyd.
All right, today is plea deadline date. Yes.
We have not reached an agreement, Your Honor.
All right, Ms. Ferguson. I need a jury trial. Is this going to be a jury or bench?
Jury, Your Honor.
All right, I need a jury trial on this case before the new year.
No, no quiet, don't talk to anybody.
All right, your jury trial date is going to be November 10th. State, if you can make sure a discovery acknowledgement is done on Limon, he's on page 8. There's going to be a jury trial November 10th. All right, just have a seat and your attorney will bring your reset form. Once you've signed it, you're excused. You're welcome.
Is that actual trial date? It's not called last
Yes,
anything?
that's trial.
Okay, thank you.
You're welcome.
You can have some.
All right, while Judge Boyd is between contestants, let me remind you tonight, 8 p.m. East, 5 p.m. Pacific, join us right here on the Courtroom Files YouTube channel for Sidebar. We have a panel of wonderful folks from this channel, minus Dan, who's still on vacation, but, you know, I'll be hosting, scary though that may be, tonight, 8 p.m. East, 5 p.m. Pacific for Sidebar right here on the Courtroom Files YouTube channel. It'll be live, which means anything could happen. And since I'm running it, which means really
Are y'all
anything
ready
could
on
happen.
Ruben Villarreal? Yes.
Okay, so I texted him this morning a reminder that when we spoke earlier in the month, he was gonna actually be here. He didn't respond to my messages, but I did get a message from his mother just a few minutes ago. And she says that he was taken into custody in Bandera and then transferred to Denton for, he was on probation. And so I'm thinking they must have filed an MTR based on this case.
So he was on probation out of Denton?
Correct, or Dallas County. And she says that he was taken into custody and then transferred from Bandera to Denton. So he's not.
All right, state
Yes,
on Ruben Villarreal, defense is telling me that he has been taken into custody in another county because he was on probation out of Denton County.
Okay, that was on Ruben Villarreal.
Yes. So what we're gonna do, Norma, how long would it take you to set up a Zoom for Denton County? All right, so what we'll do is we'll recall it for Monday, and if it turns out that for some reason he's not there or he was released,
Okay.
then the court will issue a warrant.
Yes, Your Honor.
So we'll bring it back on November 3rd.
Okay.
Okay.
All right, thank you.
Judge.
You're welcome.
All right. Well, there's always something happening with Judge Boyd. We'll see if anybody else comes on down. You know, we haven't checked in on yet this morning, though. We haven't said hello to Judge Dad. So maybe we'll see what's going on back in Michigan. And we'll switch on over there. We'll see what's happening with Judge McNally. Good morning, Judge.
Nance,
Alexander McCandless, two. Okay, Lance Alexander McCandless, 233-4185. Good morning. Your name?
Good morning, Your Honor. Lance McCandless.
So I had the court to school program at South Flat Rock, and I didn't get back here till about 20 to 10, and now we've had some problems with the computer, so my apologies to you.
No
What
worries.
did you and Emily talk about?
That I'm gonna do minimum of 6 hours of community service.
Minimum of 6 hours altogether?
No, I'm sorry, minimum of 6 hours a week to make up for my fines. Instead of the $30, that'll replace the $30 that I owe a week.
Well, come on, Emily, fine. Well, I'm not going to only pay you. We're not going to only give you the equivalent of $5 an hour.
I'm not sure. She did the math, so I'm not. Honestly, don't know. She said that. I told her I could at least do 6 hours a week. I'm not entirely sure what math she came out with.
Wait, just give me 1 second. I'm going to call her over.
Okay.
All right, so you were placed on probation back on May the 1.
Yes.
So, what's that? 24.
Yes.
So
Yeah.
we got to have everything taken care of pretty soon.
Yes, we do.
Can you?
1 second, Josh.
She said she found one. How far is it from here to probation? 25 sites. I'm gonna have Jessica teach you guys how to get over here quicker, Emily.
Well, me just as I was walking in.
Your name?
You know,
Tell me what you guys talked about.
so the payment plan he has now is 35 a week.
Right.
So we talked about yesterday that he would have to do at least 2.5 hours a week to comply with that. And then his intention is now that he's going back to work Monday, that he'll also make money payments. Cause it would be 97 hours in total for the whole balance, but he's planning to pay some and do some community service too.
Jeez. I'll just say defendant can serve. He owes 1353, right? 1355. I'll say this. How about if I do this, Lance? Defendant can serve 40 hours of community service in lieu of payment of $600 in fines and costs. Okay? Defendant to be paid at the rate of 15 per hour. Defendant to be paid essentially at the rate of 15 an hour. Not paid, but that's how much you'll offset. So you'd have to serve 40 hours. 40 hours to be completed. 40 hours to be completed. or $600 to be paid by January 5th. On January 5th, dependent to pay. Yeah, I'm gonna have to up it a little bit because you're ready to graduate, 50 per week. With all money due by April 20.
Well, he would graduate.
Yeah, April 1. Is that gonna be early enough?
Well, he would graduate, the second status would be in March.
Well, then all has to be done by March 1. Okay? Does that make sense?
Yes, Your Honor.
So you can do 40 hours of community service by January 15th. That'll leave you with a balance of $755. And then you're to pay 50 per week starting January 5th, but all money has to be paid by March 1. Okay?
Okay, I appreciate the help. That'll help me a lot.
And we'll go from there. But get going on that community service, all right?
All right, Judge, thank you.
Have a good day. Thanks a
You too.
lot.
Yeah,
Thank
bye.
you. Morning. Gurjant Singh Banks, 25R514347. That's Mr. Puta.
Yeah, I'm looking for him. It looks like we may have lost him.
Okay, how about Ms. Trombley? Do you have her?
Yep, she's out there.
All right, Priority Waste LLC. 25F244908.
Good morning, Your Honor. Elizabeth Tremblay appearing on behalf of Priority Waste.
So, did you guys have any agreed upon fines and costs here, or is this just going to be the equivalent of the 540? Is that what we're doing?
We reduced it to impeding traffic, and I believe that fine, I looked on the website, it's 155.
I can't do that. You got two axles, 540, right?
It was a
Meaning-
misload, so when you look at the when you look at the statute, technically it was written wrong, because if you can redistribute the load so that each axle is 1 to 4,000 over, if only one axle is 1 to 4 over, then the fine should only be $200. But when you redistribute the load, they're all the legal limit. So that's why I asked for the impeding traffic.
Oh, you're getting technical on these trucking.
Starting to learn the statutes, Your Honor.
Well, that's good. Okay, listen, I mean, I'll give you the impeding, but I gotta still, if I was doing a commercial vehicle, I'm gonna have to charge you more than 150. I just want you to know that before you tender this.
So then couldn't we do the 200? That's what the
Wow.
overage would be.
If I get in trouble, I'm gonna have you represent me to the charge of the commercial vehicle impeding, responsible or not responsible.
Responsible, Your Honor.
$200. They can pay by November 21st. Okay,
Okay.
the original charge dismissed.
Thank you, Your Honor. Have a good day.
Have a good day. Thank
Thanks.
you. Hussein. James Hyde Hussein, 25R514316. So I don't know if all of you heard us, but we got a court to school program. We were in Flat Rock. I didn't get back till 9:45. We had a problem with this computer, so my apologies to everybody in here and on Zoom. You're going to plead the impeding traffic, right? You met with the department rep, and that's what you're going to do? I can't hear you. Is that what you're going to do?
Yeah.
To the charge of impeding traffic, responsible or not responsible? Okay, I'll accept your plea. $170. Cashier down the hall, you're all set. Good luck. Gurjant, Ryan Carlson. Ryan Christopher Carlson, 25R514334. Can I have Casey Licklider up here seated at the table? Your name, sir?
Ryan Carlson.
All right, you're going to plead impeding, right, Mr. Carlson?
Yes, sir.
To that charge, responsible or not responsible? Okay, I'll accept your plea. You got a clean record, or?
Yes, sir.
You do, don't you? All
I
right,
can't remember the last time I've had it.
good, good, 150. You're all set. Cashier under the hall to your right.
I was gonna ask if I might have 1 week to.
Yeah, I'll give you until the 7th. How's that?
Thank you.
November 7th. Have a good day. Thanks. Casey Licklider, Casey Wayne Licklider, 25R514331. Your name? You're gonna plead to impeding, right, Mr. Licklider? To that charge, responsible or not responsible? I'll accept the plea. What are you in high school? Yeah. What are you doing?
I'm working at the airport.
Good. Doing what?
The baggage conveyors, I do communications, I tell people when there's issues with it.
All right. You're gonna plead to impeding, right? Responsible? I'll accept the plea. 150 is your total. Speeds dismissed. Okay? You're all set. Have a good day. Go right down to the cashier. Dario Latrice Brown. 25R514346. Could I have Isabella Clayton seated up at the table here? Ma'am, good morning. Your name?
Ariel Brown.
How are you doing?
Good, how are you?
You're smiling. It's a good thing. Huh? All right. To the charge, you're going to plead to impeding?
Yes.
Hey, you got to be careful. You had like 3 of these in the last year, right? To that charge, responsible or not responsible?
Responsible.
Please accepted. 170. Cashier into the hall to your right. I'll dismiss the original charge. Slow down. Be careful. Good luck. Isabella May Clayton. Come on up to the podium. 25R. Drive 14335. Your name? You're going to plead to impeding, right? Is that what you want to do? You sure? You don't want to come in and cross-examine the police officer, play lawyer? You don't want to do any of that? Sure? You're charged impeding, responsible or not responsible? I'll accept the plea. You're all set. I'm just playing around. 150. The speed's dismissed. Good luck. Here, Brittany Shante here.
Can I have the 1 week to pay?
Yeah, we'll give you till November 7th, okay? Good luck. Have a good day. Thank you. All right.
See you in the court anymore.
Brittany Shante here.
Lady in the jacket, I was assuming. If I see her, I'll send her.
Okay.
Hey, Will, can you call out for a Brittany Hare? Brittany Hare?
I'll do it right now.
Thank you.
Phone's out there.
She left?
She must have left. We'll call for it. No answer.
All right, Brittany Shante here, 25F244795, A and B. Defendant here but left. Issue warrant. Yes, I just love how. So she was complaining. I'm going to put these stickers on here, Lisa, because I just need to remind myself. Flat Rock's court to school day. Got back around 9:45. Defendant complaining that she'd been here. Well, it wasn't scheduled till
9:40.
9:40.
I sent out new notices to all the 840 people, telling them 940.
Oh, okay. She was complaining. She got saying she was here since 8:40, but she didn't. Okay. All right. I'm gonna just issue a warrant and forfeit the bond 2,010%. It's always the ones that don't show up the first time. You know that? I mean, she's complaining. She should have been here October 16th. I wonder if she'll take that into account. Default judgment was already entered on the expired plate when she didn't show the first time. That'll remain in effect. Is Mr. Poot out there yet?
No, I do have Mr. Hallman for Schneider, if that's
Jamie
in there.
Jamie Lee Schneider, 25F244636, A, B, and C. Can you look? Child restraint. Okay. All right. Solomon, your name?
Yes, thank you, Your Honor. Attorney Zachary Hallman, appearing on behalf of Ms. Jamie Lynn Schneider, who is here with me in my office. Ms. Schneider, could you say your name for the court, please?
Jamie Lee Schneider.
Does she stand mute, waive formal reading for purposes of the arraignment on the improper plea?
Thank you, Your Honor, yes.
Okay, and then she's going to plead the child restraint and no proof of insurance, right?
Right, both civil infractions she's pleading responsible to.
All right, name the charge of child restraint violation, responsible or not responsible?
Responsible.
To the charge of no proof of insurance, responsible or not responsible?
Responsible.
How old was the child? You have to have that child in a seat restraint, right?
Yes.
How old was the child?
3.
Okay, why did you have the child in there? You got to make sure you do that.
Your Honor, if I may, I did review the report, and she was pulled over in her subdivision because of the improper plate. The officer performed a search. Her child was in the car. They were looking at deer at the end of her street. She would never, I know because I know Miss Schneider, ever take her child out into the main road or anything.
Does she have insurance now?
Yeah, she has insurance.
Have you
now.
seen
She's
it?
Corrected the plate. Yes, I have. Her full license.
But you've seen her
Everything's
proof.
taken care of.
Hang on. You've seen her proof of insurance?
Yes, Your Honor.
And it's in effect on this
It's in
car.
effect. Yes.
All right. I'm going to charge 145 on the no proof. I'll cut it down to 100 on the child restraint. Can she pay the 245 today?
Yes, Your Honor. Thank you.
She can go right on 33court.com with her case number and make the payment. Okay?
Thank you, Judge. Have a great one.
You too. Have a good day. Thanks
You
a
too,
lot.
bud.
Nice
Thank
having you.
You too.
All right.
That's all we got.
Well, it seems like that's all they've got going on right now in Judge McNally's court. Very interesting. Maybe we'll see if he comes back in a little while. Of course, a couple of people not showing up for court. Always a bad decision. Always a bad decision. But speaking of bad decisions, let's go to a place where you find yourself there when you've made bad decisions and you're trying to get out of the situation that you're in. Of course, I'm talking about Louisiana, the Louisiana Board of Pardons and Paroles. Sure, let's go there and see what's going on. And I'm sure we'll get a denied out of this, but here we go. In just a moment. Yes. They do this to me every time.
Good morning.
There we go.
Our board is called to order. It's 9:09 a.m. Today is Thursday, October 30th, 2025. Could you call the roll, please?
Ms. Renata?
Here.
Ms. Singleton?
Here.
Mr. Prater?
Here.
Mr. Tillis?
Here.
Mr. Freeman?
Here.
All right.
Madam Chair, we have a quorum.
Thank you very much. Our first item, we will allow public comment on a request before any action or vote is taken. Our first item under regular business this morning is review and approval of the minutes from yesterday, October 29th, our regular meeting. Those are in your packet. Are there any corrections? Hearing none, I'll entertain a motion to adopt the minutes.
I'll make the motion.
We have a motion by Mrs. Stapleton, second by Mr. Tillis. Is there any objection? Hearing none, the minutes are approved. Thank you. Then our next item under regular business is consideration of applications for clemency. And our first case this morning on the docket is at the State Police Barracks. Morning, Captain. Would you and your staff please introduce yourself for the record?
Yes, ma'am. Good morning, everyone. Captain Patrick Washington. It's me again.
Okay. Thank you very much for accommodating us. And we have Mr. Kennedy with us.
Yes, ma'am. Desmond Kennedy, 495-912.
All right, Mr. Kennedy. So let me read some identifying information into the record and we'll get started.
Yes, ma'am.
So, Mr. Kennedy, you're classified as a third felony offender.
Yes, ma'am.
You were sentenced in Lafourche Parish
Yes, ma'am.
in February 2014 for a home invasion conviction. You received a 20-year sentence. You don't have a parole eligibility date, but you do have a good time date, which is in January 2029. Is
Yes,
that
ma'am.
correct?
Yes, ma'am.
Okay, thank you. Your case was assigned to Mr. Tillis, seated to my far left. I'm going to turn it over to him.
Good morning. Hey, sir. Good morning. How you doing? All right. Warden, could you tell us a little something about Mr. Kennedy, please?
Yes, sir. First of all, thank y'all for having us this morning. We greatly appreciate it. Seems like it's been a long time since I've seen all of y'all.
Yeah.
Desmond is one of our offenders who works at the headquarters. They call it a campus, the headquarters campus. And he works in a very secure location. I could talk about his job performance. I could talk about his institutional record, but the thing I want y'all to hear from me today is what he's doing now. And that's he's working in a program, and I'm sure y'all are aware of, Beyond Bars with the Louisiana Crime Stoppers. Just this past Monday, he and Rashawn Williams were able to go to New Orleans and participate in the National Crime Stoppers Convention, and we got some really good feedback. In fact, one of their session was one of the best sessions that the place had. I've seen firsthand the impact that these young men are making on the lives of teenagers who are some at risk, some not, but it doesn't matter where they are. They're hearing a message of what one mistake can do to change your life. And like I said, firsthand knowledge of what it's doing and how it's impacting the youth in our community. So I'm very grateful for that. The other thing I will tell you about his commitment as a parent and as a husband. Every opportunity his wife and children get to come, they do. And he, even behind bars, is a positive role model in their lives. I'm glad that he's with us, but I look forward to seeing him move forward, progress, and grow. So thank y'all.
Thank you so much. Mr. Kennedy. Yes, sir. Tell us something about yourself. What caused you to be incarcerated, and what are you doing now to better yourself, please? Okay, first off, I want to thank y'all for this opportunity. First of all, thank God for the opportunity, and thank y'all for bringing me before y'all to be heard. I'm incarcerated for a home invasion. On January 20th, 2013, I come to prison on a home invasion. It was a drug deal, and I went back and kicked the guy's door in, me and a couple other guys. And went back, on bad intentions. And first off, it was wrong. I had no business of putting the victims in that traumatizing situation. It could have went both ways where lives could have been lost. And I really shamed those people and shamed my family. And I just want to apologize to the victims because I never had the chance to really do that. And I want to say I'm sorry to them for putting them in this position, traumatizing them. So I come to prison, and my redemption journey started right then and there because I had to ask myself if I wanted to keep putting myself through this and put my family through this. And I took the necessary steps possible. I took every class possible, and I went back and actually facilitated all of the classes. In the notable classes, I took anger management, and that's what I had problems with, actually dealing with anger and acting out of emotion instead of logic. So I took anger management, and that class actually helped me to deal with conflict resolution. And it showed me how to deal with anger in the right way instead of the wrong way. And it's easy to walk away instead of just provoking a situation to be worse than what it is. So I developed all of my spiritual grounding. I took New Orleans Baptist Theological Seminary. That taught me how to go to God if I have problems and to deal with my problems the right way. And it also it gave me that spiritual grounding. It helped me navigate through my incarceration, and it gave me a real spiritual balance. I went back and actually facilitated that class also. Experiencing God helped me too. And one that really, really taught me something was victim awareness. Why victim awareness? It was because it shows the trauma that we cause people whenever we commit these senseless crimes. So I got into juvenile awareness, and I started teaching the youth, talking to the youth in prison. And that's when my youth journey started, with talking to the youth in prison. And I saw the impact that it actually made on teaching these youth and how to deal with the conflicts that they had, and everything don't have to be handled out of violence. So well, I heard a story during victim awareness from a lady. She lost her daughter, and it hit hard for me because I have kids, and it's like everybody that was affected by my crime. It made me realize that, hey man, you can't keep putting yourself or putting others in harm's way. So I did everything I was supposed to do. I come to the state police barracks June 25th, 2018. I've been here ever since. And that's when I met with Mr. Don Capola of Crime Stoppers. And at the job that I worked at headquarters. And I was seeing a lot of the teens come to prison. And I was just seeing them come through there, and it did something to me because, like, when I was seeing those kids, I was seeing my sons. And I got with Mr. Don, and it was a conversation that me and him had, and I told him, I'm like, everything these kids doing right now, like, I wonder if they really understand the trouble that they are causing themselves and other people. So we came up with the initiative Beyond Bars, and we started that to try to curb the crime and put preventative measures in place to talk to these kids and share the testimonies of the stuff that we've been through and everything our crimes cause. So I've been doing that. It's been successfully changing lives. I did a lot of back to school events where I gave away free haircuts to the kids that I encountered. And upon my release, if I am granted, I want to go back to barber school to get my instructor license to where I can open up a barber shop, and all of the kids that I impact, I'm able to help them, not just by talking to them, but giving them an opportunity to be better people.
Very good. Very good. How old were you when you committed this crime?
I was 23. 22, 23.
Were you on drugs? Were you using drugs then?
No, sir. Not like that, but not that night. But I have done drugs in the past. And the drug that I've done was ecstasy and marijuana.
Okay. Have you had any classes on drug?
Yes, sir. I took NAAA during my incarceration.
Okay. Thank you so much. We're going to ask some more questions later on, but you have some people here on your behalf. Oh, man. In person, we have Miss Kennedy, your wife, Miss Capola. I'm sorry, Don Capola with Crime Stoppers, and Johnny Dunham Crime Stoppers. And you have your sister-in-law, Patrice Cox, your sister-in-law, Gloria. How do you pronounce that? Naveen, your mother-in-law, and Miss Cox, Marquita Cox, your sister, and Adrian Coleman, your brother-in-law. We have 3 speakers that's gonna speak on your behalf, and I guess we'll have your wife first. Knows a little about you. You wanna go up to the podium and tell us what you want us to know about him?
Yeah. First of all, I want to say thank y'all for having me and allowing me to speak this morning. I am Desmond's wife, Lanita. I'm here to testify on his transformation. I speak on behalf of our children as well. He's proven through his humility, his consistency, his faith, and accountability. He's ready for the next chapter. I believe in him. We all believe in him. We're gonna all hold him accountable. He is loving, compassionate, caring, and supportive, even from behind the walls. He shows up for the kids, he's there for them, he prays with them, and he holds them accountable for their actions. He's a respectable person to kids, and we all respect him because we respect what he has to say. Having him home for the kids, it will give them that father presence that they need in their day-to-day lives. Sometimes a phone call, a few hours of visitation just won't cut it because they're at critical stages in their lives. We also understand that transitioning home for him is a major change, and we're making adaptations at home to be available, our family, so that we can hold him accountable. We just want to be equipped with the tools that he's going to need, and us, with him coming home, so we can be ready. We are going to do counseling, whether that's individual, as couple, as family, whatever we need. We also have the spiritual covering from our pastors, who's going to hold us accountable. As his wife, I'm not going to accept anything less than what I know he's capable of. He's been showing me his best lately, so I'm not settling for nothing less. So he will have to keep up the good work. Everything that we're doing at home, we recently relocated here to Baton Rouge, outside of the area where the offense occurred, so that we can be in the midst of all of the positivity and the resources and the connections that he's made during his incarceration. So a stable home, reliable transportation, all of the things, we're being intentional about choosing our next steps as we prepare for him to come home. He had a moment when he spoke at a youth event with the kids through Crime Stoppers, and he was overwhelmed by the response from the children. And he realized that that was his purpose. A lot of people, they are able to find their purpose in difficult situations like he has. So it really solidified that for him. Granted, he's going to continue to work hard. He's going to continue the work that he started. He's going to strengthen our family. And he's going to mentor the youth. And he will restore our home and expand his ability to reach the young children who desperately need guidance and hope from someone who understands their struggle. Thank you for your time.
Thank you so much. Next, on Crime Stoppers, we have Mr. Capola.
Good morning. Yeah, thank you for having me. So Des and I go back around 7 years. First met him at the Violent Crimes Unit, State Police Headquarters. He worked on the floor that Crime Stoppers offices on. As he mentioned, you would see these kids coming in and out, getting arrested, and they have no clue. So he and I collaborated, said, hey, we need an initiative through Crime Stoppers, and that is Beyond Bars, Choices, and Consequences. Des and Rashawn Williams, we go to schools, talk to the kids, they share their stories to these kids, and you would not believe the impact that they have had on these children. So we started this the latter part of 2024, and we're full steam ahead. Desmond is committed. If granted a release, he's like, I'm with you until the end. And that says a lot. We communicate on a daily basis. We plan ahead for our next events. As Ms. Kennedy said, we were just in New Orleans, Louisiana at the Crime Stoppers USA Conference. And these are Crime Stopper coordinators, directors, law enforcement from not only across the United States, but across the world, internationally. The impact that was made on them with the program that we started here by a simple conversation. It was one of the best sessions of the conference. We will go to a school, the kids afterwards sidebar with Desmond. If it's a troubled kid, I will give that kid my contact information so they can reach out to me in attempts to contact Des. Maybe it's something they messed up over the weekend. Maybe they just need that little extra support. So we have a conference call and he listens, he instructs, he gives advice, whatever he can do for these kids to change their life. And you wouldn't imagine the impact. The Department of Corrections, they were at Estruma High School with Mayor Edwards, interviewed Des and Rashawn, and it was a great program that we are continuing to grow. My phone rings daily from schools within the non-parish area that Crime Stoppers covers, requesting them to come. And I'm sure Captain Washington, when he sees my phone call, he's like, here we are, which is a great problem to have. And we just hope that he is given an opportunity to continue to work with Beyond Bars from a different perspective than he is now. So thank you. Please consider what's best for he and his family. And you know, I'm a great friend, and I consider him and his family, you know, part of mine as well. They stuck with me.
Thank you so much. Thank you. Mr. Don?
Thank y'all for having us, letting us talk in favor of Desmond. I'm Johnny Dunham. Never thought I'd be here asking for clemency. I was retired police chief, 32 years with PRPD, executive director for Capital Region Crime Stoppers. But over the last 5 years, I've got to know Des at working at the BCU, and then with the Capital Region Crime Stoppers Beyond Bars program. And I'm so impressed with the work that he does with us, even before he came in with us to help. You have to understand, Don and I would go into schools, and you have two law enforcement, present law enforcement guy, retired law enforcement guy trying to talk to youth, at-risk youth. It would go in one ear and out the other. You couldn't even get them to put down their cell phones. When Des first came with us to Beyond Bars, went to GROFF Academy. I'm not sure, I'll never forget. He started speaking. Initially, they had their phones and all up, and watching their faces and the fact that they started to drop their phones, and listen to Des, his story. You know, just the issues that he had growing up. A lot of these kids had the same issues, and it connected. And Don and I were like, "Wow, this is working. You know, this is really starting to get through." I mean, we have done events at schools, Livonia, Baton Rouge schools at Estruma, Livingston Alternative School. We have been to so many schools, and we have gotten, you know, we cover a 9-parish area, like Don said, and we've got sheriffs. I got the sheriff in Assumption that just called me the other day. So I heard about the program from Sheriff Thibodeau and Point Capee, and you know, they're constantly now calling saying, "Can you bring the Des in LA to here?" So the program's working. It's been great. You know, if there is anybody watching Des and, you know, every day at work and everything else, it's not just about the program, it's just about his attitude. And the fact that you can tell If the goal of the board is to, give clemency to somebody that you consider reformed, then Des is a prime candidate. And I can't think of any inmate that would be more deserving of clemency than Desmond Kennedy.
Thank you so much, Mr. Dunn. Ed, you got some big guns talking for you, and we appreciate the work that Crime Stoppers is doing. Are they talking about you?
Sir, I want to first start off by thanking them for being here for me and my family, because it just touched me in a whole different way. Not just hearing them speak, because being in the action of doing the things you do, you don't think about the impact that you make on the people around you. And that's how passionate I am about what I do and who I do it for. At Geo Prep, I spoke to these kids and I was explaining how I came up and the things that I experienced coming up. And seeing these kids really react to me how they did when I gave my testimony, God showed me right in that moment that that's my purpose. God will use my testimony to change these kids' lives. And how I am with my kids, see, I treat these kids like they're my own. And I hold them accountable like they're my own. And I just try my best to pour back into these kids. A lot of these kids don't have the opportunity to have people in their lives that are able to pour from them, pour into them, and also understand them. And I understand because I was once delinquent also myself. And all I just try to do is try to give them a positive outlook on life and try to give them the reality of the choices that they make. I didn't have a perfect life, and I have learned over the years not to blame nobody for the circumstances that I was into, because my own choices led me there. And I try to tell these kids to be accountable for every decision you make, because it's a ripple effect. And they don't understand that ripple effect and what it does. Like, everybody loses. I had just spoke to a kid yesterday, to be exact, and I told this kid that I could recount all of my times in the streets. I never won nothing. Ain't nothing about the streets is glorifying. Ain't nothing in there, man. I have so many losses that I had in the streets, and it's just keeping yourself accountable, man. And talking to these kids holds me accountable also, because I have to be accountable, because now I'm a leader and I have kids that follow me. So I want to be the positive example for them.
Thank you so much. Maybe some of my colleagues might have some questions.
Des, you damn sure can talk the talk. But give me some assurance here. I mean, what you did to those people wasn't that great, made them strip and all of that. So what kind of effect you think you had on your victims?
First off, I want to apologize again for the humiliation, the trauma, everything that happened that night. It wasn't supposed to happen. And the things that I've done to those victims shouldn't have happened to those people. They did not deserve that in no form or fashion. I could sit here and say I'm sorry 1,000 times, but if I don't change the person that I am and don't be accountable for what I do, then what sense it makes for me to even show sorrow if I'm not changing or being a better person? And those people did not deserve that night. I could say a drug deal went bad. Still, that does not. I had no business being in that position to where I put those people in there to have to deal with that. And I'm not here to say that I deserve anything. I'm just asking for mercy, because those people didn't deserve that. They didn't deserve that on no account.
That's a good answer. Okay, thank you.
How many years have you served of your 20-year sentence?
13 in January, sir.
And that includes time before you were sentenced, correct?
Yes, sir.
Okay, 13. What happened to the dog?
I'm laughing because honestly, that situation, I don't know what happened to the dog after we got arrested. I don't know if the dog was returned back to their own or whatever like that, but that was very stupid also.
But y'all didn't hurt the dog, right?
No, sir.
Okay, that's all the questions I really.
Well, it seems like your life was a pathway leading to what it ended up that night, because prior to that, you had numerous arrests.
Yes,
and
ma'am.
on that count, a total of, at different times, 24 worthless checks. So how did you make out those checks? And was it from individuals' checkings account? And did you make restitution? How did that go?
Actually, it was from my own account. So
Okay.
I'm gonna explain something that I did that was very, very stupid on my behalf. And this is the false ideologies that's being taught in the streets. So I was selling drugs and I would put money into an account and I would burn that account out. And what I would do if I take a loss in the streets, I would write those checks to recompensate for what I lost. Stupid. Yes, it was. And that's where all of that came from.
All the charges were on you for worthless checks.
Yes, ma'am.
That explains it. I couldn't understand how it got like that. And then just like Mr. Freeman was talking about, I mean, from 2010 to 2014, you know, there was this pathway.
Yes, ma'am.
I think you just cared less and less about the crime and more about what you wanted. I can only imagine what those victims went through that night. That was your crescendo. It really was. It ended up in that. And so there is victims in something like this, and they don't get over it overnight. Yes, so you place the fear in them that who knows how long that it will last. And also, I did want to say that all law enforcement is opposed to you getting out early, getting a commutation. That's what I wanted to say.
I just have one thing to ask you. You know, we talked about the victim of your home invasion, and you said you didn't do drugs, you sold drugs, right?
Yes, ma'am.
So how many victims do you think you got in that?
Oh, a lifetime of them. I be so embarrassed sometimes when I sit back and think about how I came up in a household with a mother on drugs, and I sold the same drugs that decapitated my mother.
Yeah, you saw what it did to her.
Yes, yes, ma'am. And
so let's talk about your children. How many kids you got? You got 5 kids?
6.
6.
Yes,
What's their ages? What's their ages?
They are 18, 17, 16, 14, 13, and 15.
13, 14, 15, 16,
Yes.
17. Okay.
Yes.
Same mother?
No, and that's me, and the mothers combined. Well, me and my wife combined.
Your kids, her kids, and y'all's kids.
Yes, I call all of my kids. Yes, ma'am.
I understand. Yeah. Okay. Well, all I have to say is you're very lucky that your wife has stood by you all this time.
I'm so thankful and grateful to my whole family that has stuck by me through this time. And that's what makes it even harder for me to look at the victims, because here it is, I'm blessed to have this support.
Okay. Well, we're going to move on. Okay. Are there any other questions? All right, we're ready to vote, Mr. Tiller.
Mr. Kennedy, I think you've done some bad things. And I see the remorsefulness in you. I see that you've changed, and we need more guys like you to help these young guys. You got 4 big guns with you, Captain Washington and your friends here, and especially your wife.
Thank you.
And I hope you don't disappoint them. My vote today is going to be to commutation of sentence to 13 years.
Mrs. Stapleton?
Thank you.
My vote today is to deny, based upon your extensive criminal history and the number of victims seen and unseen by you that your crimes have caused, complete law enforcement opposition, and I think your sentence of 20 years was a fair sentence considering everything that happened.
Mr. Prater?
I take into consideration very strongly what police chief here that with Crime Stoppers now and what the captain says about his behavior now, and I look at all the reports, and I think this is the kind of person, the reason we're here is to try to sift out the wheat from the chaff, if that's the term. And I think he's got the potential to be wheat. And so my vote is to grant to immediate parole eligibility.
Mr. Freeman?
You changed my mind. I'm not gonna lie to you. I had deny written all over my paper after I read the offense report, but you gave me the answers I wanted to hear. I do think you need to be on supervision, so I'm also gonna grant with immediate parole eligibility.
Thank you, sir.
All right, Mr. Kennedy, I've been impressed with what the captain had to say. I'm impressed with you overcoming a lot of odds based on where you came from. And I'm glad to see you making a positive impact. You could do some good. I agree with my colleagues. My vote today also is to vote that your sentence be commuted to immediate parole eligibility. So you did get 4 votes to commute your sentence. So that's the recommendation we will make on your behalf. Good luck to you, sir.
Thank y'all so much.
Captain, that concludes our business. We're going to sign
y'all
off.
again
All right. That is approved or commuted. Very, very good. Well, we don't see that too often from the Louisiana Board of Pardons and Paroles. I wasn't sure how that one was going to go. That seemed, that definitely seemed like it was going to go in a questionable direction there, but very interesting. Well, all right. Well, we're just past the top of the hour. This is where we typically end the show, but I'm the substitute teacher. I'm the fill-in host. I'm the guest host. And I've been giving you guys a little bit of overtime, and I don't see why we can't keep doing that, right? I mean, why not? I think you guys want a little bit of overtime. Why not? Let's do it. Let's see what we've got here. What's still going on out in the court world? We'll take a quick look here. You know what? Maybe we should head back out to... We should head it back out to Judge Boyd. See what's going on there. See if she's still got some... it looks like she's got a contestant coming on down, so I think we could do that. Let's check in with Judge Boyd.
All right. Are we proceeding on the motion to revoke?
We're asking for additional time. His sex offender therapist, Mr. Wyatt, in Idaho, was not available this week. He's not available to November 4th. I've been trying to talk to him. He's out. That he may have some information, may help guide the court as to what will happen with this MTR, Your Honor. So we're just asking for a little bit more time.
All right, state, any objection to their witness appearing by Zoom?
Oh, by Zoom, no.
All right, so Ms. Ferguson. And when did you say he'll be in?
He should be back to the office November 4th.
All right, Ms. Ferguson, if you'll set this for a motion to revoke the week of November 4th, please? All right, so that will be your final setting.
Your Honor, the only thing I would ask is maybe another day that week, because if he's coming back on the 4th, he may not be back into the office on the 6th. Let me make sure. He's coming back on, election day. And,
We'll see. We'll set it for November 6th and we'll see where we are.
oh, okay, thank you, Your Honor.
All right, thank you. You're welcome. Ms. Abrams, it's going to be set for November 6th and witnesses can appear by Zoom. Is this going to be contested? Defense, is this going to be contested?
What I call soft tested.
All right, she says a soft contested. Any objections to the probation officer appearing by Zoom?
No objection.
All right, so witnesses can appear by Zoom, Ms. Abrams. All right, thank you. All right, anyone else ready? Thomas Wagner. All right, has the evaluation been completed?
Judge, it's scheduled for November 7th. And there's I think a status conference in the magistrate court for December 17th, based on, I guess, whenever that is complete.
Okay.
But I did receive like a Zoom invite link, I think, to the evaluation.
When's the evaluation?
I'm sorry.
Let's see. For what?
All right, Norma. Recall this because that evaluation is supposed to be done on November 7th. I want to make sure that he's not lost in the system. Can you recall that the week of November 17th? All right, so we'll be back on November 17th to see if the evaluation was completed.
Could we do the 18th? Is that possible? All right, thank you.
right.
Can I ask a question?
Sure.
Did you receive some letter from me stating that I had 6 witnesses to the county burglary?
So what will end up happening is if there are witnesses that you want the court to hear from, your attorney will arrange that. But if it's in the form of a letter, then your attorney has to make sure that the state has that and they have no problems with my reviewing it.
Okay.
Okay. All right,
Thank
thank
you,
you.
Judge.
Anyone else? Which page?
Escalante? Yes.
Oh, please come forward.
Excellent. Oh, okay. This is the actual motion set on. It's asking for clarity. He's letting know for some space. Melissa has the appeal and put some, I gave them both. Okay.
Good morning.
All right,
Your
good
Honor.
morning.
How you doing today?
Oh, I'm doing great. How are you doing?
Good, just a little cold.
Oh, it is not cold in here.
Go down there.
Oh, yeah, I know. I always have my students take tours at the jail.
Yes.
And I know it is freezing and I actually had them take a tour back there and where they house inmates. And I know it's freezing. Yeah, they tell me there's a reason they don't give people sleeves and they keep it cold.
All right.
So, All right, is this a motion to revoke?
It is, that motion enters the case. No, I'm sorry, motion revoked, you're right.
Did I
I
see?
think we're just set for the bond. I don't think the MTR was set today.
All right, but I still need to. look at
Sure,
this.
sure.
Yeah, it's set the bond, that's right.
All right, and I don't have, all right, thank you. Yes. Thank you. All right, the court is calling 2024 CR 1359 State versus Jose Manuel Escalante. Could I have parties announced for the record?
Melissa Alvin for the state.
Raymond Martinez from Mr. Escalante.
And are you Mr. Escalante?
Yes, Your Honor.
All right. You were placed on community supervision on May 13, 2024. And you have been remanded without bond, and defense is here to request a setting of the bond. Is that correct?
Yes, Your Honor.
And state, have you had a chance to review the defense's motion?
I have your own.
All right, and state, are you prepared to proceed?
Yes, Your Honor.
And have you all reached an agreement or no?
Well, I made I guess, an offer on a bond to Victoria, but I don't know if she was in agreement with it or not.
Judge, what I can tell you is, his original bond was 15, the state's recommending 30, we're asking for a little bit less, the money's a little tight.
All right, so,
Those two numbers.
all right, so do you have any witnesses?
No, Judge.
Well, the court needs witnesses to determine
But the
if
money should-
bond can be made or not.
Okay, I can talk about that.
All right, and then, of course, I will ask questions to determine what, if I set a bond, I will need to ask some questions to determine what conditions would be appropriate for bond. All right, who would you like to call?
I'll call Mr. Escalante, Judge, but before we proceed, the reason that the number one is circled on your motion is because I think that is not a correct allegation. It's probably gonna have to be an amended motion.
I don't know if the copy you have is the one I marked on, Your Honor. Yes. So the MTR currently alleges that the new number one is a possession, or I'm sorry, a manufacturer delivery PG 1 4 to 200. But in our system in Odyssey, it reflects that it's a PG 3 4 less than 28 grams, which is a state jail felony. So Vashon is amending it for us right now, but it hasn't formally been amended yet.
Okay. All right, we can go off the record for a moment.
Thank you, Your Honor.
You're welcome. All right, who's next? Yes. All right, who's here on Omar Herrera?
I am, Your Honor. Ready?
Good morning. All right, on these two?
Yes.
You need to take those two.
Yeah.
And then the PF case is in there as well. All right, probation. This is a motion to revoke as well as new cases. So I'm going to take up the new cases first, and then the court will address the motion to revoke. All right, the court is going to call 2025 CR 013815, 2025 CR 013816, State versus Omar Herrera. Could I have parties announced?
Lauren Espinoza for the state.
Joseph Davidson covering for Monica Guerrero. Mr. Herrera, will you get this?
Just before you ask that question, are you Mr. Herrera?
See.
Yes.
All right, we have an interpreter here. Could you raise your right hand? Do you solemnly swear and affirm that you will faithfully translate from English into Spanish and Spanish into English, so help you God?
I do.
All right, you can lower your hand if you'll state your name for the record.
Yes, Pamela again.
All right, defense, you may ask your question.
May I have permission to do this plea in place of Ms. Guerrero? May I have permission to do this in place of Ms. Guerrero?
Yeah.
All right. So, counsel, do you speak Spanish?
No, Your Honor.
All right, were you able to review these documents with your client through the interpreter?
Yes, Your Honor. And in addition, Monica Guerrero is fluent in Spanish. She spoke with him. He has accepted this offer, and the translator assisted me with translating everything on the paperwork for him to sign it.
Mr. Herrera, all of the documents I'm going to review with you are in English. Were those documents explained to you in Spanish?
Yes.
And each cause number, did you review the document entitled Waiver of Indictment, Reading of Information, and Rights under Article 1.051 and 26.03 of the Code of Criminal Procedure with your attorney? Did you understand it and sign it?
Yes.
Did you understand you have a right to have a grand jury review the evidence in this case, make a decision on whether or not to hold you over for trial, and also that your attorney has the right to the expiration of 2 days upon presentation of the information and 10 days to prepare for trial?
Yes.
Did you understand by entering into this plea bargain agreement, you were giving up those rights?
Yes.
Court will find that defendant has knowingly and voluntarily waived indictment, reading of information, and rights under Article 1.051 and 26.03 of the Code of Criminal Procedure. Counsel, in each cause number, have you received all the evidence and did you review that with your client?
Yes, Your Honor.
In each cause number, the court will find that the state is in compliance with discovery. Mr. Herrera, in each cause number, did you review the felony information with your attorney and did you understand it?
Yes.
Counsel, do you waive the reading of the information?
Yes, Judge.
And state, are you proceeding on the information in both cases as listed?
Yes, Your Honor.
Mr. Herrera, in each cause number, did you review the court's admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes.
And cause number 2025 CR 013815, you're charged with an unauthorized use of a vehicle. That's a state jail felony. The range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. And cause number 2025 CR 013816, you're charged with evading arrest, detention with a vehicle. That's a third-degree felony. The range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering into these pleas, you're giving up those rights. Did you intend to give up those rights and enter into pleas in each of these cause numbers?
Yes.
Counsel, in each of the cause numbers, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Judge.
Mr. Herrera, in each of the cause numbers, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No.
All right, so you have to wait till she finishes translating. Either we're going to use the translator or we're not. You understand?
Okay.
Is that how you say Okay in Spanish?
People tend to say okay, but the way to say okay in Spanish is está bien, but people have adopted okay.
Está bien.
Yes.
Está bien.
Has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No,
No,
Anyone promised you anything other than the plea?
no.
Are you satisfied with the way you've been represented?
yes,
If you're not a U.S. citizen by entering into this plea, you will be deported, denied naturalization, and re-entry. Did you understand?
yes,
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
yes,
All right, in the cause number, that's the unauthorized use, the state is requesting that your punishment be assessed at 2 years in the state jail facility. In the cause number with the evading arrest, detention of vehicle, they're asking that your punishment be assessed at 3 years in the prison. They're asking that the cases run concurrently. There's $1,000 fine in each cause number. There are no applications. They're taking in consideration 2025 PF 36552, 2025 CC 013527, 2025 CR 013528. And also this will be running concurrently with 2025 CR 003736 and 2025 CR 003886. Did you understand that to be the plea?
yes,
Defense?
Yes.
State?
yes, Judge.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes,
By signing that you're waiving your right to appeal, the only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
yes,
Counsel, have there been any such motions?
No.
Then in cause number 2025 CR 013815, how do you plea?
no context,
And cause number 2025 CR 013816, how do you plea?
no context.
State any evidence to support the defendant's plea?
Yes, Your Honor, in both cause numbers, state offers states exhibit 1 in all attachments.
No objection, Your Honor.
In each cause number, did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes,
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
yes,
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
yes,
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same.
All right, well, Judge Boyd reviews the state's exhibits there. TCF Live, overtime. Michael Groff filling in for Dan Soul all week and next week. And tonight, 8 p.m. East, 5 p.m. Pacific for Sidebar. Join us there.
And each cause numbers, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, waive TSI.
Anything you wish to say on behalf of your client?
We would ask that you follow the agreement, Your Honor.
All right, and cause number 2025 CR 013815. Court is finding you guilty. The court will sentence you to 2 years in the state jail facility, give you credit for any time served. There's $1,000 fine. This will run concurrent with 2025 CR 003736, 2025 CR 003886, and 2025 CR 013816. Taking consideration 2025 PF 36552. And there's to be restitution, if any, to to Lamarcus Minter, Minter. Is there anything else with regards to sentencing under that cause number?
No, Your Honor.
And cause number 2025 CR 01386. The court is finding you guilty. The court will sentence you to 3 years in the prison. Give you credit for any time served. There's a $1,000 fine. This will run concurrent with 2025 CR 003736. 2025 CR 003886. 2025 CR 013815. Taking consideration 2025 CC 013527 and 2025 CR 013528. Is there anything under that cause number with regards to sentencing?
No, Your Honor.
It's just that last one you read is CC, not CR.
Ah.
13528.
All right, any objection to the court changing the plea paperwork to reflect CC?
No, Judge.
It's nothing further from the sentence.
And each cause number, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes.
In each cause number, because these are plea bargaining agreements, because I followed your plea bargaining agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because these are felony convictions, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand? All right, and could someone do me a favor and 2025 CR 03736? I only have the First Amendment. Do you have the?
You're three, 3886, Judge?
Yes. No, 3736. Only on that one, I only have the First Amendment. No. And on that one, let me see if I only have the First Amendment on that one too. Yes, on that one, I only have the First Amendment as well. All right, thank you. And on both of these cases, are you proceeding on the same allegation in each motion? Okay. All right, then I only need it for that. Thank you. All right, the court is calling 2025 CR 003736 and 2025 CR 003886. Mr. Herrera, in cause number 2000, in each cause number, did you review the motion to revoke community supervision and the First Amendment motion to revoke community supervision in each cause number?
Yes.
Are you the same Omar Herrera who's placed on who was placed on community supervision in 2025 CR 003886 for the offense of unauthorized use of a vehicle on June 12, 2025 for a term of 3 years? Is that you?
Yes.
And are you the same Omar Herrera who was placed on community supervision in 2025 CR 003736 for the offense of unauthorized use of a vehicle on June 12, 2025 for a term of 3 years? Is that you?
Yes, ma'am.
State, are you proceeding on the same violation in each motion?
Yes, Your Honor.
Defense, any objection to the state reading the allegation once and for the defendant to respond true or not true for both cause numbers?
No objection.
All right, State, you may proceed.
Violated condition number one, on or about the 28th day of June 2025 in Bear County, Texas, the defendant Omar Herrera committed the offense of evading arrest or detention with vehicle in violation of condition number one.
And each cause number, how do you plead?
True. ¿Verdad?
Yeah.
True.
Violated condition number one, on or about the 28th day of June 2025 in Bear County, Texas, the defendant Omar Herrera committed the offense of unauthorized use of a motor vehicle in violation of condition number one.
And how do you plead to that?
True. State will waive the remaining.
Any objections to the state's waivers?
None.
Did you understand by pleading true to violations 1 and 1? And each cause number, the court could find it true, grant the motion, and sentence you up to 2 years in the state jail facility?
Yes.
Knowing that, do you still wish to plead true to violations 1 and 1?
Yes.
Court will find 1 and 1 true. Is there a proposed agreement?
Yes, Your Honor, the proposed agreement is to sentence to 2 years and run this concurrent with the two cases he just put on 2025 CR 013815 and 2025 CR 013816.
All right. Defense, is that the agreement?
Yes, Judge.
Mr. Herrera, are you asking the court to follow that agreement?
Yes.
Are you waiving your right to appeal?
Yes.
And cause number 2025 CR 003886. As previously stated, the court is finding 1 and 1 true. The court will grant the motion. The court will sentence you to 2 years in the state jail facility, give you credit for any time served. There's to be no contact with Angel Torres. The last name is spelled Quezas. Restitution, if any, to Jarrett Elias McGarity. And this will run concurrent with the following cause number. 2025 CR 003736. 2025 CR 013816. 2025 CR 013815. Is there anything else in that cause number with regards to sentencing?
Yeah. No, Your Honor.
And cause number 2025 CR 003736. The court will sentence you to 2 years in the state jail facility. You credit for any time served. Restitution, if any, to George Torres. Oh, I'm sorry, State, you may be excused. There's to be no contact with Vivian Ortega, Christy with the K, Jimenez, Friday, Regina Ortega. There's to be no residing in households with minors, no unsupervised contact with minors, and no driving without a valid license, and proof of insurance. And this is to run concurrent with 2025 CR 0038886, 2025 CR 013816, and 2025 CR 013815. Is there anything else with regards to sentencing in that cause number, counsel?
No, Your Honor.
And each cause number, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes.
Because these are plea bargaining agreements, because I followed your plea bargaining agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because these are felony convictions, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
Yes.
All right, good luck to you. You need to do better. Otherwise, you're going to find yourself living at the prison or living at the jail.
Thank you, ma'am.
You're welcome. Gracias. De nada.
And he's got a laundry list of cases there. It looks like more like it would fit on a CVS receipt. My goodness. A lot going on there. All right. We are well into overtime, but one more place I want to stop before we get out of here and call it a day, because we don't go here very often, either when Dan's hosting or when I'm here. So I figured we'd head up Washington, the state of Washington. This is Battleground, Washington, more specifically. And this is Judge Wheeler. Let's see what's going on up here for a few minutes, and then we'll call it a day.
All right, Mr. Mitchell, if you want to come up here to the podium, sir. Hello, sir.
Hello.
Can I have you state your name and date of birth, please, for the record?
My name is Duke Mitchell. 6/17/05 is my date of birth.
Mr. Mitchell, you're making a first appearance arraignment on a charge called driving while suspended in the third degree. It's what's called a simple misdemeanor in the state of Washington. It's subject to 90 days in jail and a $1,000 fine. I did review the associated police reports with the case. I did find what is called probable cause. Because this is a criminal charge, sir, you have several important rights today, including the right to remain silent, the right to a speedy and public trial, and the right to an attorney. Would you like to be screened for a court-appointed attorney?
What would that really do for me?
Court-appointed attorney, because it looks like you've never been to court here in Washington, would represent you on your case and be able to assist you in the legal process.
Yes, Your Honor.
Okay. I'm going to ask you just a couple questions about your income to see if you qualify. Do you receive any manner of state assistance?
No, Your Honor.
Are you employed right now?
Yes, Your Honor.
Can you estimate about how much you're earning per month after taxes?
I'd say 2,500.
Okay. And how many folks do you support on that income?
Just me.
Are you sure it's 2,500?
Probably less, but I get paid weekly, so I don't
Okay.
really know.
That's okay. So do you work full-time?
Yes, Your Honor, but it's been getting down because I work at a truck wash, and
Okay.
with the weather, it's just been less and less hours.
Okay. So would you say that it's your income is because of the time of year is decreasing?
Yes, Your Honor.
Okay. I am going to go ahead and appoint an attorney. I'm going to assign Steve Sowards. So, Mr. Mitchell, what we're going to do today is enter a plea of not guilty that preserves rights and keeps all of your options open. I'm going to set two court dates. The first is going to be your attorney. You don't need to be there. It's going to be on November 12th, 2025. Your next mandatory court date is going to be on December 11th, 2025. That can be either in person or on Zoom. but that is a mandatory court date and you have to be here in one of those capacities. Your release conditions are to violate no laws, appear at all mandatory court dates, to notify the court of any change of address or phone number. You're not to drive without a valid license and insurance, and I am releasing you on your recognizance. So Mr. Sowards can be in touch with you. Is there a phone number I can write on the form here?
Do you want me to say it too?
Yeah.
971
971
757 6568.
6568.
Yes, sir.
Okay. So Mr. Mitchell, at that very far desk over by the door, we're going to get you some paperwork that has your court dates and your release conditions. I then want you to go to the same place where you checked in for court, get a business card for Steve Sowards, call his office tomorrow, let him know you've been assigned as his client, okay?
Thank you.
Good luck, sir. Thank you. Joshua Newton. Hello, sir. Can you state your name and date of birth for the record, please?
Joshua Newt, September 7th, 1995.
So, Mr. Yep.
On this one, I do not mean to interrupt. We
sorry.
are handing up a motion to dismiss with a potential material witness issue.
Got it. So, Mr. Newt, when you disappear for 6 years, sometimes the law enforcement that was associating your case is no longer around. I would not make it a habit or a practice to do something like that. You're probably here under the best of intentions. But at this time, I am going to go ahead and sign that order of dismissal. We're going to get you a copy of that at the desk by the door, and I wish you well.
Thank you.
Thank you, sir.
I have one other dismissal, but I don't know that he appeared in regard.
Okay. Is Jordan Hunt in the courtroom? Come on up here. And if I could have you just state your name and date of birth, please, for the record.
Jordan Hunt, 4986.
So, Mr. Hunt, I have an order of dismissal without prejudice here. Now, I want to explain to you what that means. It's very common in cases where people's blood is drawn. In the next 2 years, when the blood draw result comes back, if it shows alcohol or illicit substances in it, you're going to be charged. The court, like I said, has 2 years from the date of your incident to charge you. The court will communicate with you by sending you a summons in the mail.
Okay.
If I was you, I would make sure to keep an updated address with the court. Because if the court sends something to an older address, you are deemed to have what is called constructive notice, and a warrant will be issued. Do you understand?
I understand.
We're going to get you some paperwork at the desk by the door. Once you have your documents, you are free to go.
Thank you.
Thank you. All the way over at the desk by the door. By the door. Thank you. All right, so I have Mr. Sowards and Mr. Wallace. Who's ready?
I'm ready, Your Honor, on Mr. Catlett.
Okay, sounds good. Mr. Catlett, can you hear the court, sir? I'm not getting any audio from Mr. Catlett, which is sometimes what happens when we're trying to connect in audio. So let's just wait a minute here and we'll see if we get it.
Okay. Yeah, I got it turned on now.
Okay, I do hear it. Mr. Catlett, can you tell me your name and date of birth, please?
Jason Catlett, 2977.
Okay, your attorney, Mr. Wallace, is with us here in the courtroom. Go ahead, Mr. Wallace.
Thank you, Your Honor. Mr. Catlett's currently on a stay for a PCS charge here in Battleground. He's alleged to have missed a court date in September, and also alleged not to have yet turned in proof of a substance abuse evaluation. What we're asking for is another shot, and we're asking to set over approximately 4 weeks for Mr. Catlett to work on getting that evaluation and to provide proof to the court of the evaluation. I will say, just so that the court is aware, it sounds like there's a Superior Court matter that he's being held on. So there is a possibility that he's not out of custody when we're back in 4 weeks. And if that's the case, then we probably won't have that evaluation completed.
So I'm going to set this out to December 4th, just because we're running into the Thanksgiving week. If it's we truly set it at the 4 week mark. So Mr. Catlett, you're not being held on this matter. Your next court date, sir, is December 4th, 2025. If you are in custody, that will be at 8:30 in the morning. If you are out of custody, that will be at 1:30 in the afternoon. Do you have any questions at all about that, sir?
No, I just need to get my evaluations when I get out of here, correct? And be there December 4th.
Well, it sounds like you may have some more complicated issues in Superior Court, but yeah, that does articulate what you need to do in our court. So, Madam Clerk, the probation form is ready to be printed. Thank you, Mr. Catlett. That concludes your hearing, sir.
Thank you.
Thank you.
Mr. Sowards?
Mr. Richter in the other is ready, Your Honor.
Good morning, Mr. Richter. Can you hear the court, sir?
Yes.
Thank you. Can I have you please state your name and date of birth for the record?
Ethan Richter, 9899.
Thank you, Mr. Richter. Your attorney, Mr. Sowards, is with us here in the courtroom. Go ahead, Mr. Sowards.
Thank you, Your Honor. Unfortunately, Mr. Richter has picked up a felony matter. According to jail records, there's a $25,000 bond on those felony charges. He has spoken to his attorney quickly once, but she is on vacation this week. In order so that he can have an opportunity to confer with his felony counsel before we resolve his battleground charges, we are proposing that with the waiver, we move his case to November 13th with commencement of speedy trial rights starting on November 13th. I did discuss this with Mr. Richter. He understands. And I also advise that if he does make bail, he'll need to be here in person on November 13th at 10 a.m.
Mr. Richter, I don't think he's being held on our matter. I just want to make sure I'm articulating speedy trial time correctly.
That is correct. Battleground at this point has no hold. The only hold according to jail records is the felony bail.
Right. So Mr. Richter, in doing a speedy trial waiver beginning November 13th, you're giving the city of Battleground 90 days from that date if it became necessary to bring you to trial. Do you understand your right to speedy trial, sir?
Yes, sir.
And are you in agreement with the waiver?
Yes, I am.
All right, I'll accept the waiver. I'll find it knowing, intelligent, and voluntarily made. Your next court date, Mr. Richter, is going to be on November 13th, 2025. I'm going to circle on your form here 10 a.m., sir. Certainly, if you are still in custody, you'll be brought over more around the 8:30 hour, okay?
All right.
All right, thank you, sir. That concludes your hearing. Miguel Parra Ruiz. Hello, sir.
Hello,
Hello. Can you state your name and date of birth, please, for the record?
my name is Miguel Parra, and 030681.
Okay. Mr. Parra, you're before the court on a charge of no valid operator's license without ID. That's a simple misdemeanor. It's subject to 90 days in jail and a $1,000 fine. I did review the associated police reports with the case. I did find what is called probable cause. Because this is a criminal charge, sir, you have several important rights today, including the right to remain silent, the right to a speedy and public trial, and the right to an attorney. Would you like to be screened for a court-appointed attorney?
Judge, I will require a translator.
Okay. I think we have a Spanish interpreter that'll be here at 9 on Zoom. All right, so have a seat. We'll recall your case. Ivan Protopopov. His Proto-Popov. I know there's another Popov I'll be calling in just a minute. Mr. Proto-Popov, can you state your name and date of birth, please, for the record?
Ivan Protopopov, 040493.
Mr. Proto-Popov, you're making a first appearance arraignment on 2 charges. The first is a simple misdemeanor called driving while suspended in the 3rd degree. It's subject to 90 days in jail and a $1,000 fine. The second is driving with a suspended vehicle registration. That is a gross misdemeanor, subject to 364 days in jail and a $5,000 fine. I've reviewed the associated police reports with your case. I have found what is called probable cause. Because this is a criminal charge, sir, you have several important rights today, including the right to remain silent, the right to a speedy and public trial, and the right to an attorney. Would you like to be screened today for a court-appointed attorney? I'm going to ask you some questions about your income to see if you qualify. Do you receive any manner of state assistance at all?
No.
Are you employed right now?
Yes,
Can you estimate about how much you're earning per month after taxes?
around 4,500.
Okay. And how many people do you support on that income?
2 kids, wife.
So 4 people
Yeah.
total. I will go ahead and find you do qualify for a court-appointed attorney. Court will assign Steve Sowards. Mr. Proto Popoff, we're going to enter a not guilty plea today that preserves all of your rights and keeps all of your options open. I'm going to set 2 future court dates. The first is just for your attorney. That is going to be on the 12th of November, 2025. It's not a required court date for you. Your next mandatory court date, sir, is going to be on the 11th of December, 2025 at 10 a.m. You can be in person that day or on Zoom, but you do need to be present. Your release conditions are to violate no laws, appear at all mandatory court dates, to notify the court of any change of address or phone number. You are not to drive without a valid license and insurance, and I am releasing you on your recognizance. So your attorney can be in touch with you. Is there a phone number I can write on the form here?
Yes, 808-785-7167.
Okay. Mr. Proto Popoff, at that very far desk by the door, we're going to get you some paperwork that has your court date and your release conditions. I then want you to go to the same location where you checked in for court. On the left-hand side, get a business card for Steve Sowards. Call his office tomorrow. Let him know you've been assigned as his attorney, okay? Sorry, as his client. Thank you, sir. All right, Mr. Papriska, if I could have you unmute, sir, and state your name and date of birth, please, for the record.
Can you hear me, Your Honor?
Yes, I can.
Fantastic. Nathaniel David Papriska, September 4th, 2001.
Mr. Papriska, you're making a first appearance arraignment on a charge of protection order violation. That charge, sir, is a gross misdemeanor. It is subject to 364 days in jail and a $5,000 fine. I did review the associated police reports with the case. I did find what is called probable cause. Because this is a criminal charge, sir, you have several important rights today, including the right to remain silent, the right to a speedy and public trial, and the right to an attorney. Would you like to be screened today, sir, for a court-appointed attorney?
Yes, Your Honor. Please.
I'm going to ask you some questions about your income to see if you qualify. Do you receive any manner of state assistance at all?
Negative.
It appears that you are currently employed.
Yes, Your Honor.
Can you estimate about how much you earn per month after taxes?
A little less than 4,000, but as of right now, 3,400 due to separation pay.
Okay. And how many folks do you support on that income?
3, Your Honor.
I'm going to find you do qualify for a court-appointed attorney. Court will assign Kenneth Wallace. Mr. Papriska, we're going to enter a not guilty plea today, sir. That preserves all of your rights and keeps all of your options open. I'm going to set 2 future court dates. The first will be on the 11th of November, 2025. That's a date just for your attorney. It's not a required court date for you. Your next mandatory court date, sir, is going to be on the 4th of December, 2025 at 10 a.m. Pacific time. You can be in person that day or on Zoom, but you do need to be present. Your release conditions are to violate no laws. That includes the existing orders that are in place in Clark County. Appear at all mandatory court dates to notify the court of any change of address or phone number. I'm releasing you at this time on your recognizance. So your attorney, Mr. Wallace, can be in touch with you. Is there a phone number I can write on the form here?
Yes, Your Honor. 360-936-1384.
So, sir, we're going to send you some contact information for your attorney. We're going to mail it to you along with your court information. Are you still getting your mail on Pollard Street in El Paso, Texas?
Yes, Your Honor.
All right, we will send the documents there, sir. If there's nothing further, you can log out.
The time on December 4th was 10
10
you said?
a.m., 10 a.m. Pacific time.
Pacific. Thank you,
Yes,
Your
sir.
Honor.
Thank you.
All right, ladies and gentlemen, I believe with that, we can call it a day here at TCF. Michael Groff having filled in for Dan Soul for another day. And what a day it's been. We've been to Louisiana. We went to Michigan. We did. We were up here in Battleground to kind of close out the day. Let me see if I can't get. There we go. There I am. Hi. All right. So a few notes here. Just real quick. Want to take this opportunity to once again thank Barbara for the channel membership and for the super chat. I want to thank Mama Joan, Grandma TCF. For the super chat, $10 super chat there. Bailey with the super sticker. I think I covered everybody. If not, thank you so very much. The super chats and super stickers while I am here. Guest hosting, those will go to me. Everything else goes to the channel and to Dan and making sure that this channel stays up and running. And that's what we're trying to do here. We're trying to keep everything held together by some razor wire and duct tape while he is gone. And of course, we wish him safe travels and him and his family and all of that. All right, we'll be back here tomorrow. But before that, I want to mention tonight, 8 p.m. East, 5 p.m. Pacific. Tune in for Sidebar. What are we talking about tonight? Well, you saw a little bit of what we're talking about with the paroles and pardons and clemency and all of that. We're going to get into some of that tonight. It should be an exciting conversation for sure. Yes, Dan will not be joining us, but hey, the four of us and the executive producer, my OAO, the sweetest of all time, the Asian sensation and proprietor of sweetchildaz.com.org and the Facebook page of the same name, Sweet Child Arizona, my Michelle will be joining us as well for she's the executive producer while Dan is gone. Because I need somebody else in here. Obviously, as you can tell, I have had a lot of trouble running some of this stuff, but I am getting better. We only had like 3 or 4 screw ups today, so things are getting better. All right, all of that having been said, please, I want you guys to be safe out there. Have yourselves a glorious rest of your day. Once again, thank you so much for joining us and hanging out with us on Overtime. We're having a lot of fun here, and that's really what this is all about. It's a great community, and you guys are spectacular for supporting it. See you back here tomorrow. Goodbye, everybody.